Buenas and half a day. The committee is back from recess. The time is now 1:43 p.m. If we can have order in the public hearing room, please. Order. So again, public notices were sent out in compliance with the open government law. Notices of today's hearing were published in the Guam Daily Post, provided via email to senators, stakeholders, local media, posted to the Guam Government of Guam Public Notices website on December 27, 2023 for the 5-day notice, and Tuesday, January 2nd, 2024 for the 48-hour notice, thus meeting requirements. I'd like to acknowledge my colleagues that are here today, Senator Tello Taitigui, Speaker Therese Terlahi, Senator Tom Fisher, Senator Frank Blas Jr., and Senator Chris Dueñas. The purpose of this second part of the public hearing is to receive testimony on two bills. The first bill is Bill number 175-37 COR, sponsored by Senator Chris Dueñas, co-sponsored by Senators Frank Blas Jr., Jesse Lujan, Thomas Fisher, Dwayne Nicolas. It's an act to amend Section 48101C, add new sections 48101F, G, and H, amend Section 48104A, 48104B3, B4, C, and D, to add a new section 48104E and amend and renumber sections 48106, 48112.1, and add a new section 48112.1B and 48112.2. To repeal section 48125, 48126A, and add a new section 48125, 48126, 48127, 48128, 48129, all of Chapter 48, Title 10, Guam Code Annotated, relative to include nitrogen-reducing systems, establish administrative process, and create the Sewage Disposal Assistance Fund. The second item on the agenda is to hear testimony on Bill number 50-37 COR, sponsored by Senator Thomas Fisher. It's an act to add a new section to Title 11, Chapter 6 of Guam Code Annotated, prohibiting the sale of flavored tobacco products within the territory of Guam. The rules of conduct for today's hearing is as follows. Those called to testify will be in the order beginning with the government agencies, followed by those that confirm testimony in person or by Zoom in advance with my office by Friday, December 29th, 2023, or prior to today's hearing. It will be in the order according to the sign-in sheet. To ensure that all public comments are captured, I ask that all written testimonies be submitted to my staff as soon as possible, so copies can be made and are made available for those that are present here. And also to include in the Bill's committee report. We ask that your testimonies, because due to the large volume of attendance here today, we ask that testimonies be limited to 5 minutes. If you need more time, we will go a second round, and we can then complete your testimonies then. Those attending via Zoom will be first recognized by the chairperson before speaking, and videos must remain on. Digital backgrounds are not allowed. Only participants that have confirmed their attendance with my office will be granted access to the hearing. Please provide state your name prior to submitting or giving oral testimony, as well as your organization and position for record-keeping purposes. Senators will be given an opportunity at the end of each panel to ask questions. But I ask my colleagues, due to the high volume of those testifying, respectfully ask the questions be concise, comments as well be concise to facilitate participation of the public. Questions and testimony shall be confined to the substance or nature of the agenda. Personal inference as to character or motive of any senator or any individual testifying is not permitted. And so now I'd like to invite any government agencies that would like to provide testimony at this time. I believe we have Assistant Attorney General Botha. Is there anyone else here to testify on Bill 175 from the government? Okay, yes, Guam EPA for sure. We have Administrator Michelle Lastimosa, Brian Bearden, and is there anybody else from the government agencies for Bill 175? Okay, before we start, I'd also like to acknowledge Senator Chris Barnett, who's joined us here today. and also to allow the sponsor of the bill to provide opening remarks.
Madam Chair. First of all, I'd like to thank my co-sponsors, Minority Leader Frank Blas Jr., Senator Jesse Lujan, Senator Tom Fisher, and Senator Dwayne T.D. Nicolas. Due to the fact that we have a lot of subject matter experts as well as very passionate individuals who have been aggrieved by a great injustice, I will just make a brief set of comments before turning it over to individuals who I believe will convince people that are in attendance here that passing this bill is the right thing to do. What the bill does, it corrects an injustice that exists between arbitrary decisions being made in law, particularly by EPA, that treats decedent estates differently than parental subdivisions. Two existing pieces of property which are issued, one unfortunately after the original owners of the land had died. This injustice is intolerable and should not be accepted. The second thing it does is it provides for a solution that was asked for by the government, none less than our great Captain Bearden. In a September 1 meeting in 2023 with EPA, as well as other subject matter experts, and in particular, the Guam Association of Realtors and other individuals in the meeting, the only discrepancy in this legislation that was brought forward, and it will be corroborated by the members of GAR who attended, was the lot size. Supposedly, I've got information that yesterday I inadvertently, during an interview, made mistakes on the lot sizes. So I will stand corrected today, as the lot sizes will be discussed, I'm sure, by the subject matter experts. That was the only thing, and like I said, I think the GAR members will corroborate that. The third thing is it establishes a timeline for rules and regulations to be promulgated in order to be able to carry forward this very important legislation, and to make sure that all the T's are crossed and the I's are dotted, so that, like everybody sitting in this room, we can protect our environment, because no one in this room or no one on Guam wants to jeopardize our drinking water, but they certainly do want to have the decency of living in an affordable home. The last thing it will do fundamentally, it will establish a fund to be operated by EPA in order to manage this program going forward. That fund will not be commingled with any other fund and will be allowed as an additional source for EPA to be able to do its job. Earlier today, a presentation was made on a scenario that was presented, I believe, as a worst-case scenario of what would happen in times that are not even contemplated, such as a 1/8 acre piece of land to be building a house, a septic system, and a leaching field. Everybody in this room knows that's a ridiculous scenario. I would like to take the comments of Simon Sanchez that is very important to this legislation, as we did a press conference months ago on this important legislation, whereby the other scenario was a density that was enormous over the aquifer and near pump stations. It's unfathomable to think that such a large-scale production would be done in density without waterworks demanding that they be allowed to bring in their sewer system in order to reap the benefits of the economies of scale and what it costs, to the money and revenue that they would get by hooking up to a sewer system. The third thing, and this is why I'll go to the final of what this bill doesn't do, the third thing that was not contemplated was exactly what we're doing today, which is introducing a Type 4 nitrate removing proven system internationally installed in many countries and throughout the world, primarily in the country of Japan, a country that loves to take care of its people and understands that in rural areas, it's important to have systems which can mitigate issues of contamination. In fact, in many areas where these systems are installed, these nitrate removing systems, they're right abutting rivers and streams, freshwater sources, an ecology that's vibrant and living with no high levels of contamination when it comes to nitrates and the like. We will have a subject matter expert today. In fact, we have 2 companies that represent these systems that are going to be testifying via Zoom so that the people of Guam can understand that we are not doing this without really knowing what we're doing. And we're not doing this on the basis of what the government told us to do. So in closing, as we listen to the subject matter experts and the presentation today that I think we will all gain a lot of knowledge over, what the bill doesn't do is the bill does not endanger our aquifer, endanger our environment, and endanger our drinking water. Because when this bill is passed and the Type 4 system becomes law for nitrate removing, it'll be the premier on-site, on-lot sewage managing system on Guam. As a matter of fact, it will be far and away better than all the broken pipes that are running throughout Guam dumping sewage into our groundwater. It will be far and away better than all the pump stations that break down regularly and overflow massive millions of gallons of sewage into the groundwater. It'll mitigate the fact that you see trucks running up and down Route 4, dumping sewage into the sewer that they've picked up from all of these places that are contaminating our aquifer because we're not containing our wastewater currently in a very manageable way. Every citizen who has this system on their property will be an environmental steward. So with that, Madam Chair, I'm looking forward to the passionate testimony and proper deliberation of Bill 175-37, Sizus Maasi.
Okay, thank you, Senator Dueñas. We will now move on to the testimony phase. So I'd like to recognize Guam EPA for their testimony.
Hafa Senators. Captain Brian Bearden, U.S. Public Health Service, assigned to the Guam EPA as the Chief Engineer and Water Division Director. We do have just some slides, very simple illustrations that go along with the references that we're citing in our testimony. Could we start the slides, at least start on the first page? Thank you. I'm going to read from our testimony. Administrator Michelle Lastimosa and I will be trading off. I'll be reading the background section. She'll be giving a little bit more detail on the specific comments we have on the bill. Bill number 175-37 COR seeks to modernize the Toilet Facilities and Sewage Act, which was enacted by Guam Public Law over 30 years ago. The Guam Environmental Protection Agency believes that the act is certainly due for some modernization, given the housing needs of the community where parental subdivisions and decedent subdivisions are concerned, and advancements in on-site sewage treatment and disposal system technology, and continued protection of the northern aquifer. During our agency's regularly scheduled board of directors meeting on August 14, 2023, the agency expressed the need to bring parity to landowners who sought to develop on their properties which were the result of court-ordered decedent subdivisions. We also expressed the need to provide this parity responsibly and in a manner that would still be protective of our groundwater. Prior to providing our detailed comments on the bill, we wish to provide some background on the rationale behind the regulation of on-site wastewater disposal systems through the establishment of density requirements, for example, minimum lot sizes. The 1982 Northern Guam Lens study recognized that septic systems are one of the main sources of nitrate contamination threatening the quality of the Northern Guam Lens aquifer, which I'll call the NGLA throughout the rest of this testimony, and that limiting the number of septic systems allowed to be built above the NGLA was the primary means of mitigating this threat. Nitrate is a pollutant with known risks to public health. The current regulatory maximum contaminant level, or MCL, for nitrate as nitrogen is 10 parts per million, or 10 milligrams per liter, and was originally established by the U.S. Public Health Service in 1962 to prevent illness and death in young infants. Can we move to the next slide, please? The basis for the MCL was the prevention of methemoglobinemia, or blue baby syndrome, in which nitrate-contaminated well water, when used to mix formula, results in the infant's blood not being able to carry enough oxygen to the lungs, from the lungs to the rest of the body, which in some cases leads to suffocation and death. Between 1945 and 1970, 2,000 cases of drinking water-caused infant methemoglobinemia were reported worldwide, with a case fatality rate of 8%. And we provide the references in our letter. Nitrate is also used throughout the U.S. as a general indicator of the presence and degree of groundwater pollution. Septic systems, in addition to nitrate, are additionally responsible for a large variety of other pollutants which enter the groundwater through their ordinary operation. These pollutants include human wastes, household cleaners, laundry detergents, fabric treatments, pharmaceuticals, and a variety of emerging contaminants, including per- and polyfluorinated alkyl substances, or PFAS, which have been found in GWA's wastewater and are therefore expected to be present in septic system wastes. Septic system waste is likely responsible in large part for the presence of the background levels of PFAS observed throughout the NGLA, separate from the known PFAS hotspots, which in some cases, in some areas, exceed the upcoming proposed MCL by the US EPA. Next slide. Studies conducted by the University of Guam's Water and Environmental Research Institute of the Pacific, WERI, from 2002 to 2020 reveal increasing nitrate concentrations in 58% of the wells located within the NGLA. Next slide. More recently, high-resolution groundwater modeling conducted by WERI show that nitrate levels can be expected to exceed the 5 milligram half MCL underneath densely developed residential areas. Next slide, please. Monitoring studies conducted in the CNMI mirror WERI's 2023 modeling effort, showing that areas of dense, unsewered development within the same geological formation as northern Guam, the Marianas Limestone, continuously exceed the half MCL and periodically exceed the full MCL. Next slide. In 2021, the Guam Waterworks Authority projected that nitrate levels in some parts of the NGLA would exceed the half MCL value of 5 milligrams per liter by the end of this decade, if left unchecked. In 2023, GWA's monitoring revealed that wells in some areas of northern Guam had already exceeded the half MCL value, resulting in regulatory triggers being activated, which required GWA to increase monitoring in those areas at the expense of ratepayers. If nitrate levels are allowed to continue to rise beyond the 5 milligram per liter half MCL, GWA may be required to remove wells from service or install treatment, again at the expense of ratepayers, in order to be in compliance with the law and to protect public health. The 1982 study identified nitrate as one of 3 primary pollutants of concern associated with the development of northern Guam, the other 2 being chlorides and coliform organisms, bacteria, and as a general indicator of pollution. Next slide, please. The 1982 study considered on-site wastewater disposal, such as septic systems, and agriculture to be the primary sources of nitrate affecting the NGLA, and computed a recommended maximum allowable density of 2.0 persons per acre, or approximately 1 house per 3 acres, using on-site disposal systems in order to keep nitrate concentrations below 4 milligrams per liter, or just below half the MCL. The study reduced this recommendation to 1 house per acre in the groundwater protection zone on the assumption that 2/3 of the groundwater protection zone will remain either undeveloped or unsewered. But the study recommended that these density suggestions be revisited based on actual effects and the monitoring of nitrate levels in the NGLA. The actual density of development and on-site systems within the NGLA has greatly exceeded the recommendations given in the 1982 study. The 1 home per 3 acre density recommended in the study, when applied to the entire recharge area used in the study and the calculation, results in a recommended maximum 5,800 homes in order to keep nitrate levels below 4 milligrams per liter. According to data from WERI, as cited by McDonald in 2002, approximately 15,500 septic systems were located in the recharge area of the NGLA as of 2002. Next slide. Guam EPA was granted the authority to establish lot sizes and setbacks on properties above the aquifer under the zoning law at 21 GCA section 61501C. And for the past 25 years, Guam EPA has established and the Department of Land Management has enforced a minimum lot size of 19,200 square feet, or approximately 1/2 acre, for unsewered lots over the NGLA, based on a Guam EPA memo to the DLM dated September 8, 1997, and 9,600 square feet, or approximately 1/4 acre, for unsewered parental lots in all areas of Guam. And I'll just add a note that that lot size determination from 1997 did not include decedent lots. Guam EPA's available records are not clear as to the origin of the current 1/2 acre minimum lot size. Our assumption is that lot sizes in existing laws were used without change. Next slide, please. However, it is worth noting that the current standards result in a development density of 2 times what was ultimately recommended in the 1982 study of 1 home per acre, or 6 times if all of northern Guam were to be developed at 1 home per 3 acres. 1/4 acre parental lots exceed these 1982 recommendations by 4 and 12 times, respectively. It is our current understanding that the parental lot exception was granted by Guam EPA with the rationale that such lots constituted a limited minority of unsewered development over the NGLA, a true exception to the rule. However, in recent years, 1/4 acre parental lots have accounted for about half, or 49%, of all unsewered development within the NGLA. Guam EPA does not have any estimate of the potential number of new 1/4 acre lots that may be developed if the decedent lots are also allowed, except to note that it will likely increase the overall number of 1/4 acre lots developed to constitute a majority of annual new unsewered development over the NGLA. It was in recognition of these facts and the observed degradation of aquifer quality that Guam EPA began working with stakeholders in 2019 to examine alternatives which could preserve the current lot size expectations while reducing the impact to the NGLA. One such alternative was the use of advanced on-site treatment systems. Next slide, please. The NSF 245 standard was targeted as it requires such systems to meet a minimum 50% reduction of nitrogen nitrate in wastewater. As of the date of this testimony, there were 179 NSF 245 certified on-site wastewater treatment systems commercially available from 17 different manufacturers. It was this 50% reduction figure that led Guam EPA to recommend requiring the owners of new parental lots to install such systems, with the rationale being that a 50% nitrate reduction would result in 2 1/4 acre parental lots fitted with such systems equaling the total nitrogen loading of a single traditional septic system on a 1/2 acre lot. However, Guam EPA also recognizes that such systems do not remove all other types of pollutants, and that they require considerably more operation and maintenance to function properly compared to a traditional septic system. As a result, Guam EPA recommended that the lot size exception be limited to the current exceptions for parental and decedent lots only, and that stringent oversight requirements be imposed to ensure that they function as intended. Bill 175-37 COR is largely based on previous draft legislation never introduced, to which Guam EPA was an active contributor and willing supporter. However, in its current state, the bill has been modified to allow for development densities which greatly exceed what Guam EPA had previously proposed, even with the addition of advanced on-site treatment systems. Our specific comments on the bill follow.
So Guam EPA supports most of the provision of the bill, but we are particularly concerned about the following. So the first one, Section 7, with a note that we believe that this is an inappropriate section to the main issue of this public hearing, which is to allow Type 4, an alternate wastewater treatment system to address parental subdivision and decedent lots. And particularly, it's in conflict with 21 GCA Section 61501. So Section 7, which would allow for development of unsewered 1/4 acre lots within the groundwater protection zone for anyone, provided that the proposed Type 4 advanced nitrogen reducing residential on-site disposal system is required for such lots, and would allow for the development of 1/6 acre lots for persons who subdivide following the so-called parental antecedent subdivision processes established under the subdivision law at 21 GCA Section 62-104. Currently, Guam's laws and regulations allow for the development of unsewered lots of a minimum 1/2 acre in size, and Guam EPA policy since 1997 has allowed for the development of 1/4 acre lots within the GPZ as a limited exception for parental lots only. So Bill 175-37 goes beyond what Guam EPA has suggested to allow for the development of 1/4 acre lots for anyone within the GPZ, not just parental antecedent lot recipients, and the 1/6 lots for parental antecedent lots. This would result in a doubling, a 100% increase of the annual increase in wastewater loading to the aquifer compared to the status quo, and a tripling, 200% increase in areas where land is subdivided under the parental or decedent provisions of the subdivision law. Note that these increases are on top of the increases from the 1982 study, which recommended what was already discussed above. Even with the use of advanced on-site treatment systems, this will result in a significant degradation of groundwater quality. While the proposed Type 4 systems are capable of providing very good treatment of traditional wastewater parameters, such as nitrate and overall wastewater strength, they are not capable of treating every contaminant associated with domestic sewage. As a single example, we know that these systems will not provide significant reductions of PFAS substances. And we know that domestic wastewater from septic tanks is a source of PFAS contamination to groundwater. Such Type 4 systems also require much more operation and maintenance than a traditional septic system, and failure to provide maintenance to these systems could result in a worse performance than traditional septic systems. Contamination of Guam's sole source aquifer to the point that it requires treatment in order to be consumed or used for other domestic purposes will impose an enormous financial burden and hardship upon the government and the people of Guam, in addition to negative impacts to public health. Treatment systems which remove wastewater pollutants from drinking water can cost in the range of hundreds of thousands to millions of dollars per well, as was discussed earlier this morning, just to install. And the operation and maintenance costs of such systems are also substantial. Should levels of regulated contaminants approach drinking water standards, then the Guam Water Works Authority will have no choice but to install such treatment systems at the expense of the government of Guam and GWA ratepayers. It is the opinion of Guam EPA that opening the development of unsewered 1/4 acre lots to everyone above the aquifer carries with it a significant risk of contaminating the aquifer to the point that such treatment expenses may be required. Guam EPA has consistently put forward the opinion that such exemptions should be limited to those already granted under the subdivision law, those parental lots and potentially also decedent lots, but not for everybody. But only with the provision that the advanced Type 4 treatment systems, in order to minimize the risk to the aquifer and public health, and only with the condition that the owners of such systems obtain and submit annual operating permits that require an operations and maintenance contract with an approved vendor. It is also worth noting that the majority of parental lots permitted over the past 2 years, since Guam EPA has been tracking this data, appear to have been developed by investors, not local residents. While Guam EPA supports efforts to promote the ability for individual land homeowners to build on their family properties, developers should be held accountable to pay for the infrastructure that is required to protect public health and safety, as is required in other jurisdictions and in Guam under the subdivision law. The public should not bear the risk and the cost associated with high-density, unsewered development over Guam's aquifer. Secondly, Section 11 repeals 10 GCA Section 48, 125, and 126, and replaces Section 48, 125 with a section now entitled permitting of Type 4 facilities and holding tanks. Subpart A establishes an interim permitting authority, which Guam EPA supports. However, Subpart A2 states that the interim permitting authority will expire upon the issuance of regulations by Guam EPA, and in no case later than 12 months after the enactment of the amendments. Guam EPA had originally proposed that the bill not include this deadline so that the interim permitting authority would remain in place until such time that the regulations were issued. If Guam EPA is unable to complete these regulations within that 12-month time frame, there would be potentially a long period of time during which Guam EPA would not be able to issue these permits for Type 4 systems and holding tanks. This would cause considerable hardship for anyone attempting to build on lots that require those types of facilities. Guam EPA recommends that the 12-month limit be removed. This would leave an interim permitting authority in effect until Guam EPA can complete the regulatory process. Thirdly, Section 14, Sewage Disposal Assistance Fund. This proposed addition to 10 GCA Chapter 48 would establish a non-lapsing fund into which Guam EPA would deposit all fees, penalties, and other funds collected or received pursuant to this chapter. Guam EPA supports the establishment of this fund, but believes that as it is currently proposed, this section would create an additional burden, another unfunded mandate on the agency, which would not be supported by the anticipated fees. Namely, the proposed section under Section 48-129B would require the agency to provide and manage a grant program for sewer connections or installation of on-site wastewater systems using funds collected by Guam EPA in addition to grants, which the bill would require me to make every effort to apply for. As a regulatory agency vested with the authority to permit, investigate, render a decision, and impose disciplinary or sanctions against when a violation occurs, overseeing an operational activity such as providing financial assistance for sewer connections or installation of an on-site wastewater system to which we inspect may pose a conflict to Guam EPA with its regular consolidated grant funding. And our regular consolidated grant funding will not be able to support or provide financial assistance to individual residents. We want to note that our fee collection is typically not enough even to cover the cost of one single employee, let alone the several that would require the responsibility to administer amounts to give out or administer this construction grant program. Moreover, this appears to duplicate potentially conflict with the existing GWA sewer connection program, which already receives funds. This section should be further reviewed for consistency with GWA's programs and to clarify that the program under Subpart B would be required only in the event that Guam EPA receives adequate grant funding. Otherwise, Guam EPA recommends deleting Section 48219 altogether. Section 3, which adds Section 48101G, a definition of advanced nitrogen-reducing on-site disposal system. Guam EPA recommends that the definition be changed to replace certified with the word approved as follows: that it is approved by the Guam Environmental Protection Agency. Guam EPA does not have the ability to test and certify wastewater treatment technology, which is why, under the interim permitting authority provision in the bill, third-party NSF-245 certification is required. When the regulations are eventually promulgated, leaving the certification requirements in the regulation gives Guam EPA more options to adjust in case of future changes in technology or third-party certification. Relying on third-party certification has always been Guam EPA's intention in order to prevent potential conflicts and to streamline the Guam EPA review and approval process. Guam EPA certainly recognizes the merits of this bill, and most of our recommendations, about 95% of our recommendations, are contained in its provisions. Given Bill 175-37's benefits and setbacks shared here today, we do look forward to working with the sponsors and co-sponsors in order to strike a fair and equitable balance between satisfying the community's housing needs and the protection of the Northern Guam aquifer by including language in the bill to reflect our recommendations. Thank you once again for the opportunity to share our thoughts on the bill, and we're available to answer any questions.
Thank you, Guam EPA. We now would like to recognize Assistant Attorney General Botha for his testimony.
Thank you. Havaday, Madam Chair, Senators. On behalf of the Attorney General Moylan, we'd like to present this testimony on Bill 175-37 related to the amendment of Chapter 48, Title 10, Guam Code Annotated, which concerns the toilet facilities and sewage disposal. My office is supportive of the amended provisions as set forth in Bill numbers 175-37, subject to the following commentaries, which was prepared to provide a firm basis for future planning, development, and enforcement challenges which may arise after the adoption of Bill number 175-37. And the commentaries are as follows. Most of these are relatively technical constructions that we recommend for the bill. Section 1, the words, the use of should be included immediately after. Legislation Guahan finds that located within the first sentence of Section 1, page 1, lines 2 to 3. The first paragraph of Section 1 should have language amended to the last sentence as follows: nitrate concentrations attributable to the management of sewage. Page 1, line 7. Paragraph 2, the term such contained in the phrase,
Excuse me,
quote, to permit the installation.
can you speak into the mic closer? Yeah.
Sorry. Thank you, Madam Chair. The term such contained in the phrase, to permit the installation, operation, maintenance of such facilities should be replaced with type 4 toilet. Page 2, line 4. Paragraph 2, for their installation, operation, and maintenance be added immediately after to mandate Guam EPA to promulgate rules and regulations. Section 48101C should be revised to clarify that Guam EPA is the authority providing approval for 1, the materials from which septic tanks may be constructed or fabricated, 2, the design of septic tanks, and 3, the approval of plans for site-constructed tanks prior to construction. Page 2, lines 14, 16, and 17. Section 3, the following 4 definitions should be added. Administrator for the purposes chapter refers to the administrator of the Guam Environmental Protection Agency. Board for the purposes of this chapter refers to the Board of Directors for the Guam Environmental Protection Agency. The fund means the Sewage Disposal Assistance Funds formed pursuant to this chapter, and Guam EPA shall mean the Guam Environmental Protection Agency. The term leaching fields located in the final sentence of Section 48101H should be raised to the term leaching system. Page 3, line 10. Section 5, sections 48104B3D should be revised as follows. The provisions of this section should apply to type 4 facilities as well as type 2 facilities. The term leaching systems should be replaced with the term soil absorption systems. The term dwelling should be replaced in this case with the term toilet facilities, page 4, line 2. Section 6, the language redacted in sentence 2 of section 4810414C should be restated in its entirety subject to the necessary revisions of effective dates of the bill. Section 8, all uses of the term leaching system within section 48106 A and C should be replaced with the term soil absorption system. Section 9, the term leaching system within section 48112.1 should be replaced with the term soil absorption system. The second sentence of section 48112.1b should be revised as follows. If notice prior to disconnecting is not feasible due to the existence of an emergency, the administrator shall notify the owner's authorized agent, or the occupant of the building, structure, or services in writing as soon as practical thereafter. Section 10, the term received in the first sentence of 48112.2 should be replaced with the term receives. Page 8, line 1. The term receipt in the first sentence of section 48112.2b should be replaced with the term filing. The phrase or determination of the administrator should be added to section 48112.2c immediately after the board shall either affirm, modify, or revoke any action. Page 8, line 10. The term discharge in section 48112.2C should be replaced with the term sewage, page 8, line 2. And the phrase, in the same manner as services provided in civil actions, should be added to the first sentence of section 48112.2D, page 8, line 18. Section 11, sections 48125A, 1 to 2 should be revised to clarify that the issuance of the regulations contemplated therein is through the Guam EPA. Page 9, lines 17 and 19 to 20. The words, these amendments at the ends of section 48125A2 should be replaced with this section, page 9, line 21. Section 48125A3 should be revised to clarify that payment of contemplated fees is made to the fund and to provide that the fees for construction permit applications and operating permits are to be established by the Guam EPA after its due diligent inquiry into the administrative expenses necessary for administration of the permits. It's page 9, lines 22 to 24. Sections 48125A4 should be relocated to section 48125B unless this section is intended to apply only in the interim. That's page 9, lines 25 to 27. The citation to section 1B at the end of section 48125C1 should be replaced with a citation to chapter 48, this chapter. See page 10, line 16. Section 48125C2 should be revised to clarify that operating permits are issued by the administrator and that operating permits shall include conditions as required by regulations which will be promulgated by the Guam EPA. Page 10, lines 18 to 19. Section 48125C3 should be revised as follows. Failure to timely renew an operating permit for a Type 4 facility shall be a violation of this chapter. See page 10, lines 22 to 23. Section 48126A and B should be revised to provide that authorization of the administrator must be in writing. That's page 11, lines 3 and 5. Section 12, section 48127A should be amended in its entirety as follows. The administrator shall serve a notice of violation on 1. Any person, firm, or corporation responsible for the erection, installation, alteration, extension, repair, removal, or demolition of any toilet facility in violation of the provisions of this chapter. 2. Any person, firm, or corporation in violation of a detailed statement of the approved construction documents thereunder. Or 3. Any person, firm, or corporation in violation of a permit or certificate issued under the provisions of this chapter. The administrator shall also issue an order directing the discontinuance of the illegal action or condition and the abatement of the violation by the person, firm, or corporation responsible. Page 11, lines 15 to 22. The first section, the first sentence of section 48127C should be amended as follows. The violation is not cured or abated within the time prescribed by the administrator. In the notice of violation order, the administrator may request. Page 11, lines 23 to 24. Sections 48127D and E should clarify that fines are payable to the fund. Page 12, lines 8 and 24. Section 48127F should be amended to provide that the Office of Attorney General the authority to abate, enjoin, or prevent unlawful construction. See page 13, line 3. Semicolon located after the words correct or abate a violation should be placed with a comma. Page 13, line 4. Section 13, section 48128B should be revised to provide that work shall cease upon service of the stop work order rather than upon issuance of the stop work order. Section 48128C may be removed as there is no provision of a notice requirement in section 48128, and as all work should cease immediately upon service of a stop work order regardless of the existence of emergency. Page 13, line 27, and page 14, line 1. Section 17, the effective date of the act should be revised such it becomes effective immediately after the promulgation of rules and regulations by Guam EPA. Page 15, lines 11 and 12. This concludes the commentary on behalf of the Attorney General's Office. We want to thank you for inviting us to the hearing today.
Thank you, Assistant Attorney General. So I guess now we're open for questions for the first panel. Is there any other government agency that wants to testify on Bill 175? Okay. So just to confirm with Guam EPA, so the bill is currently written will increase contamination, is that correct?
Yes, it goes from 1/4 acre minimum lot sizes to 1/6 acre minimum lot sizes for parental and decedent lots, and it allows 1/4 acre minimum lot sizes for anybody, which currently are allowed only 1/2 acre lots.
And so you're mentioning what percentage increase in contamination will it be? What's the result?
Well, going from let's see, let's take a look here. So going from the 1/2 acre lots to the 1/4 acre lots for everybody is a doubling, which is a 100% increase in wastewater loading for those areas. And then going from a going to a 1/6 acre lot compared to the 1/2 acre lot results in a tripling of wastewater loading, so a 200% increase over what we currently see as an increase every time we develop new lots.
Okay. And so we heard earlier today that there was modeling that was done in regards to 1/8 acre could produce nitrates in a well. Basically, if they tested it in the well, it would increase to, I believe, 18 parts per million, which exceeds the maximum contaminant level. And just for the information, that was even looked into. It is a real example. There was interest in creating lot sizes 1/8 an acre, and so there is a potential, if it were if it materializes, that the fact of density, that particular density would cause us to be non-compliant with the Safe Drinking Water Act. What would it take to clean up our water? I mean, is it irreparable damage? I mean, how quickly can we clean? We heard this morning that, with Dildren being in 3 of the wells, that it will take about a year for the infrastructure to be put in place. So does Guam EPA have any idea how long it will take to clean up the water once it's contaminated to a level beyond the MCL?
Well, if an MCL is violated or close to being violated and the utility is required to put in treatment, it would be the same basic time frame we heard from GWA this morning, because it would be essentially the same type of equipment. It would be pressure vessels for the filtration media, nitrates removed with what they call ion exchange resin. It sits in the same type of containers and piping systems that you would put granular activated carbon in. So anywhere from 1 to 3 years, depending on funding, to get those wells treated. As far as cleaning up, if you're able to get an area that's exceeding nitrate and get it sewered, the cleanup of that groundwater happens relatively quickly because nitrate is a soluble contaminant. It just flushes out of the system pretty quick. But if you aren't able to sewer it, then you have to install treatment, and then you're looking at that type of a time frame plus large expenses to do that.
And what would it cost the ratepayers to have these systems in place once the water is contaminated?
Well, I don't have an exact figure for that. I can just base it off what GWA told us this morning, that would cost about $1 to $2 million per well for the infrastructure to install. Then there would be annual operating costs and replacement costs for that media and disposal costs for that media. So, initial costs would be substantial, and so would continuing operation costs as well.
In regards to water policy and protecting our drinking water, would you say that prevention is the best method of protection, or cleaning up after the fact it's contaminated?
Prevention is always the best choice, because as we mentioned in our testimony, nitrate's not the only thing that's in wastewater. It's an indicator of wastewater. The wastewater that comes from a septic tank contains everything that we flush down our toilets, that we run through our laundry machines, that we wash down our floor drains. So we're talking about nitrate only. These systems are great for removing nitrate, not removing it, let's say reducing it. They reduce it. But they're not necessarily good at removing some of the other things. that we discussed that are also in sewage and that may come up as health concerns in the future, as we've learned with these other contaminants we've just learned about over the last 10 years.
Is Guam EPA considering revising their testimony based upon the finalization of the PFAS rule? Because currently they're about to come to an MCL at a really low level at 4 parts per trillion for PFOA and PFAS. And there are 4 others that are also going to be regulated as well. Would Guam EPA consider revising their current testimony in regards to accepting a higher density? And because this particular bill only addresses nitrates, it doesn't address PFAS, which is a forever chemical. It's difficult to break down in nature. And so, again, you know, we're talking about a very vital resource that should not be taken for granted. Because once we damage this resource, we have to clean it up for sure, but it may be harder, and we're not guaranteed that we're going to get, you know, the water that we started with before it was contaminated.
That's a good question. Maybe we could consider that because, as we know, there have been studies in the States. We've looked at them, we've read them, where people have monitored the effluent coming out of septic tanks from single-family homes, and they find PFAS in those, and that effluent comes from just general household use as well as human waste. So yes, a greater density would lead to more PFAS contamination. And what we're seeing right now in northern Guam is that not all of northern Guam exceeds that proposed EPA MCL yet, but they're close. So it's possible that increased density could result in more GWA wells needing to have that treatment system installed to meet that MCL, because we're talking about adding more pollutants to the aquifer with every new septic system. Basically, that's how they work, or advanced treatment system. Either way, they're still putting that wastewater into the ground.
The other thing that to note is that there are wells that have increasing nitrate levels, and so I know the math is that, you know, if you have a nitrogen reducing system that can reduce the nitrate load by 50%, therefore you can double the density, right? But really we have to also think about the bigger picture, where if we need to reduce the nitrate and not keep it at the same load, then we're talking about more stringent technology that can reduce it. So, in my experience too, that the claims of a company needs to be verified. We can't accept it at face value. And that goes to your point about maintenance contracts, right? Because just because it says it's a 50% reducing system doesn't always guarantee that it's going to live up to that claim. And so this is something that we really have to caution, you know, if we're going to entertain, you know, increasing density, you know, based on the claims of a company.
Yes, I think the way that we look at it is that this is a risk management decision, right? These are systems that have technology that can provide good treatment, but there's a risk that they will not, based on any number of factors, which includes operation and maintenance, or just variations. Is like my Mazda 6 I purchased is supposed to get 28 miles per gallon in the city. It only gets 22, right? So we don't know what these systems are really going to do in an actual usage situation. So our approach when we had worked on the original version of this bill was to limit this exception to the current exceptions that exist only, which is the parental lots and the decedent lots, because people already have lots that have been subdivided. We don't want to interfere with their ability to develop those lots. But what we did not want to do in order to mitigate that risk was not just to not open it up to everybody, because then we probably will see a substantial percentage of these systems not be operated properly and not be overseen properly, and they may eventually cause worse aquifer damage than just a regular septic system if they're not operated properly.
And so the language you proposed, the change in the language of the bill, is that sufficient to address what you just said?
Yes, well, Michelle, go ahead.
So, you know, in our discussions, when this first began, it was to address the disparity for those landowners with subdivided lots under a parental subdivision or decedent lots. And like Brian said, opening it up to everybody is not what our intent was. This bill was not supposed to be a free-for-all where landowners can now subdivide their properties into smaller lot sizes, which would then increase the population density and contribute to the increasing nitrates in our groundwater. So, this really was meant to address and rectify a broken system for those landowners that have parental subdivisions or decedent lots. So I think that's the main point, is that we're not wanting to, hinder progress or hinder those landowners from developing their properties. We are just saying that it is not right. It's not a good decision. It's a bad decision to allow and open it up to everybody. Otherwise, we're going to see, these smaller 1/6 of an acre lots in northern Guam, central to northern Guam over our aquifer, which is going to contribute to increased nitrate levels. I mean, that's all we're saying, is this bill, or the intention of this bill, I think, was to address those landowners, not open it up as a free-for-all.
And do you provide language, trying to look at your testimony, do you provide alternate language to satisfy what you're trying to achieve?
We did not. We did provide it to Senator Dueñas originally, the alternate language. That's not what was included. We could provide that again.
Yeah, I would like to see that. Another thing, in 2019, I believe Guam EPA asked for a AG opinion regarding the discrepancy between the zoning law and the Guam water regulations. Did you ever receive that opinion?
We did not.
Okay. Are you going to attempt to try to get an opinion from the current AG?
We certainly can request for an opinion.
Okay. Okay, I think those are my questions for now, so I'll open the floor up to the sponsor of the bill.
Madam Chair. And you're correct, Mr. Bearden. I went with the original language, as other who will probably be in contravention to your position will approach the mic and explain that. But I also, as you know, in the meetings that we had, said I'm amenable to an amendment to ensure that we can get something done as opposed to nothing. But we'll see what happens in the evolution of that as well. Kevin Bearden and Ms. Lastimosa, I mean, I cannot overstate that every single time we get this chart and graph that's presented to us shows, as far as I'm concerned, an unmitigated presentation. As EPA, isn't it really your duty to push GWA, and isn't it also GWA's duty to install sewer lines where you got massive density buildup in order to be able to, first of all, mitigate that issue, and second of all, I'm sure it's also included with economies of scale. I mean, this representation on this 1/6 on parental, then decedent, then opening it up, really flies in the face of what Simon Sanchez testified to earlier, and the CCUS testified to. Infrastructure follows development. So it's like we're comparing apples and oranges here, because of the fact that when those densities start to increase, then sewers should follow. Doesn't that make sense? Wouldn't EPA mandate that?
So EPA's laws on sewer connection are dependent on the developer. So if someone comes in and proposes a subdivision, and this is under the subdivision law, they are required to put that infrastructure in. What we see instead is a lot of people trying to evade that subdivision law in a lot of cases through this parental subdivision. They might subdivide a property once, get 4 lots, avoid the subdivision law, and then do it again and again until they end up with 16 lots, for example. Guam EPA does not have any regulations that require the provision of infrastructure ahead of any kind of development, other than if someone comes in and proposes the development, then there are requirements that they provide that sewer or that they connect to that sewer. Every place I've ever lived, the developer is responsible for putting in infrastructure, not the utility, because the utility is the ratepayers and the public. The public doesn't pay ahead of time for development to come in. It's the other way around, usually, where I've worked.
Roger that, but on Guam we have the system development charge. And our CCU has told everybody on Guam that you got to start paying now for everything that's going forward, because everything that was built before was paid for by the other ratepayers. So now we're accumulating millions and millions of dollars in GWA under a system development charge, and it's sitting in a bank collecting interest, and I don't see any sewer lines being run. I don't see any monitoring of development to say now this is development, because parental subdivisions has resulted in, and now decedent will be resulted in. On Guam, yes, you may be talking about some large-scale developments that are plotted down as that. But on Guam, we have a government agency that we pay, and that we pay into a system development charge, that when the density starts to exist, it's their job to come in and put in that system, because they want everybody to be customers. One of the reasons why GWA is losing so much money in a lot of cases is because they're not doing their due diligence and putting it in and creating more customers. Instead, they're just sitting by and letting everybody suffer and leave island because they can't build a house here, because their $100,000 or $150,000 lot means nothing to them. I just want to see if you guys want to really be a part of the solution, or just be, as a lot of people call you, Captain Sorry. It comes into my email all the time, Captain No.
Well, it's not Guam EPA's authority or responsibility to administer the system development charge or how it's used. It's just not our jurisdiction. We're regulators, so you can call me Captain No if you want. Although I say Captain Yes about 1,400 times a year on other permits. So I don't know how to answer that question. You need to talk to GWA, I suppose.
I just think it's an abrogation of a responsibility. You are the lead agency to protect our environment. This should be something that's a collaborative effort. I mean, to just stand there and go, well, we're just regulators, you know? I mean, that's crazy, because obviously when you come from the other end and tell us what we can't do, you're not regulators, you're making policy. You're making policy that is demonstrative of a government that doesn't want to do its job to help its people. And you can't stand in the way of that. You got to be part of the solution as far as I'm concerned. Otherwise, you're not doing your job.
I think we're part of the process. So in this case, when you're talking about the fees that GWA collects, like Captain Bearden said, we don't dictate what their priorities are or what they're going to spend that money on. But as regulators, when there is a law that exists that says that infrastructure is not in place, that sewer is not in that area, then we have a responsibility to say, okay, then we have to limit the lot size and the development in that area, which we do. So when we look at an area that does not have sewer, that is going to require a septic tank leaching field, or, you know, in this case, a type 4 system to be placed, then there's going to be a limit on the population density and what can be developed in that area. So in terms of being a part of the solution, we're part of the process. If sewer is not available to build 6 houses on an acre property, then we as regulators and what we're bound to enforce, the law, then we say you can't build it. I mean, I don't know what you want us to do. If you want us to say, okay, we'll let you build, unsewered units on 1 acre property if it means that it may contaminate our groundwater. We're going to say no. We're not going to say yes. I mean, and I think that it's unfair for you to attack Captain Bearden as Mr. No. He's doing his job. And I say it over and over again, he's doing his job. He's doing what is required of him to protect the people of Guam and our aquifer. And if people, want to call him Mr. No, he's Mr. No because he's doing the right thing.
I'd like to add, I'm just enforcing Guam law. I'm an executive branch employee. I'm executing the laws that were passed by this body prior to your time.
Well, I'm sorry, Captain Bearden, but a lot of people disagree with that.
Excuse me, Senator. I just want to reiterate the standard of conduct here.
I understand. I have my line of questioning.
No personal inference as to character or motive of any senator or any individual testifying is not permitted. So please, if you can
not a personal
comply
inference.
with that.
It's something that's in emails that's being stated that's absolutely true by people who are aggrieved by EPA's policies and don't agree that the law reads that way.
But the no is with justification. His Captain No is with justification. He's just not arbitrarily saying no to every development that comes across his desk.
That's
Senator.
fine. You can respond to that. But the fact is that people are entitled to their speech as well. And to put in an email or to call an office and say, this is how I feel, and this is how I feel about the disparate law. So I will close by saying that I just think it is not proper for a government agency that's supposed to be serving the people of Guam to not be an advocate and go in and work with Guam Water Works and say, absolutely, this is the way it should be outlined, and this is how system development charges should be done, in order for us to move from people spending their own money to mitigate sewage because the government doesn't put it in, and then when that density starts to exist, roll in that infrastructure like a good government would do for its people.
I'd just like to add that this bill, as I mentioned before, about 95% of it is that we worked on. This was advocated by me starting in 2019. I convened the Northern Guam Lens Working Group to start talking about this. Let's find a solution. I've been working on this solution, sir, for quite a while, 4 years. I'd like to see this come to fruition as much as you would.
That's fine, sir, but a lot of other people, many on this panel, are absolutely fighting against it and not trying to work in that vein. So that's why I have to be a passionate advocate to make sure that we try to help our people. But thank you for your work, because nobody would introduce the bill, Captain, and you know that.
Are you finished? Okay, Senator Blas. Senator Blas, you're recognized.
Thank you, Madam Chair, and thank you for the panel for being here. Camber, I just need to be able to qualify the statements, for you to qualify the statements that you made earlier with regards to a question that was asked of you about the density, and then in as far as the contamination. Can you go ahead and repeat what you had stated? You said, what do you anticipate over the next few years as far as the density if this were to pass? You may mention about a 100 to 200%.
Yeah, I'll just read from our testimony. That's directly from the testimony.
It wasn't part of your it wasn't part of the testimony. It was part of the answers to a question that was provided by you.
I was reading from the testimony again.
Yeah.
Right. So what we said was, when you go from the currently required 1/2 acre minimum lot size to a 1/4 acre lot for everybody on Guam, that's a doubling of the density, right? So that's a 100% increase in wastewater loading. And if you then take that and you compare that to the 1/6 acre lots, which is 6 homes per acre, compared to the 1/2 acre lot, right? So that's three homes per 1/2 acre now. So you have 3 homes in 1/2 acre lot, which used to be for 1 home. That's a tripling of the wastewater loading, right? So that's a 200% increase. So you go up 100%, 200%. You've got three times that much wastewater loading on that lot.
And that's
now.
with basically no regulation, right?
No, that's just density, right? So that's what would happen with a 6 acre lot.
Yeah, well,
You'd
but
have
that's
that much wastewater.
But that's based on current.
No, that's based on what's proposed.
The proposals is saying that we're going to now put a mitigative measure into this lot.
Yes, so yeah, I'm just talking about wastewater loading. That's how much wastewater is going to go into the ground. It'll be treated better with these systems. They do remove quite a bit of other contaminants. They remove nitrate down to at least 50%. They remove other contamination. But they don't remove all contamination. And you've still got that much wastewater going into the groundwater. And that wastewater then gets into the groundwater and is diluted through natural functions and then goes into your water wells, right? So there's just that much more wastewater that's coming into our drinking water. That's the point.
Okay. Current system that Guam Water Works has right now. Any leakages in as far as the wastewater?
Oh yeah, they have problems that they've been dealing with.
How much leakage?
I don't know.
We don't know.
Yeah, it's been quantified, but I don't have that data.
So we don't know whether or not any of the wastewater, or, that we're capturing 75% of the wastewater that was supposed to go into it. We could be going into the ground.
We have a much better idea. I'm just saying I don't know. They do annual sewer tests. They run TVs through that. They know which lines are leaking and which are not. They replace them. They have figures that they could tell you that. The majority of their wastewater, the vast majority of their wastewater is delivered to the treatment plants these days. They've done a lot of work to improve their situation.
But there's still leakages.
There's leaks, yes. Every time any system has leaks.
And these leakages have 100% of the contamination you're trying to filter out.
I don't know exactly what you're getting at there, but
so I'm kidding. As we're basing ourselves on a lot of the testimony that you provided was based on assumption. Is it true?
To some extent, but we do know how these systems work. We do know how the wastewater system works. We know how sewer system works.
So you can say with all certainty that if we were to go ahead and pass this bill and allow now more density, I'm going to put it in very simple language, more density, and as far as houses, that this is going to then result in a 100, 200% increase in contamination in the water. Is that what we're saying?
What I said is a 100 to 200% increase in wastewater loading, the amount of wastewater that goes in the
Wastewater loading.
ground. Yes,
So let's clarify that, wastewater loading.
that's a guarantee.
Okay, wastewater loading. Now we're talking about the particulates, in this case, the
And you're
nitrates.
talking about the pollutants. All we can talk about here is nitrate, because that's all that the NSF 245
So what do we intend to do with the
addresses.
properties if we can't do anything else other than that? Let me ask you something. Is human waste the only form of product that will produce these contaminants?
No,
that
there's other things too, which we mentioned in our testimony.
Like cows and pigs and
There's
chickens?
cows and pigs, and those are all, when we talked about the 1982 Guam Lens study, those were all taken into account with those calculations of how many people per acre could be supported when you also include the tangan leaves and the pigs and the chickens.
Okay.
In fact, that calculation tells you
So-
how many chickens per acre you can have.
Yeah, and I don't mean to be facetious or sarcastic or anything, but then if we don't do anything and we don't try to put any mitigative measures, but yet these contaminants can still come from other sources, is it then the intent later on down the road to say that, okay, you can't build a house and you can't put a chicken farm on your property?
We already have rules about chicken farms, because that is a definite source of nitrate contamination, and there are rules about that.
Okay, but now I'm talking about properties where people want to build houses and they can't build houses anymore. They didn't want to put a chicken farm, but you were leaving them to do that. As I said, I don't want to be sarcastic.
Well, I don't think any of our rules say you cannot build a house. It just says
Well,
what the
then,
size
but that's
of
what
the
I'm getting
lots
at.
need to be.
So going back to the whole concern that I have here, is this okay? Granted, yes, there's going to be more wastewater produced because there's going to be more people. But will the type of technology that this will allow or permit to occur, is there a possibility, or will it be able to mitigate some of the concerns that you would have?
Yes, and that's why we originally recommended those quarter-acre lots, right? That we could do this on the quarter-acre lot. It gives you, at least in terms of nitrate and basic wastewater loading, it gives you equivalency to a half-acre lot. Now you go to 6-acre lots, now you're increasing that density beyond even the half-acre traditional septic system. Because all we can guarantee is the 50% reduction. That's what the NSF 245 standard gives you.
Okay, well, I just wanted to find out if there's any happy medium or any, for lack of a better term, a compromise to this
Absolutely.
whole thing. I just don't want I don't want to hear that EPA is coming in here and says, I don't want to add another note to the captain, okay?
This is not, I mean, this has been promoted by Guam EPA for 4 years now, that this is the mitigation. We use this on the quarter-acre lots for the parental.
So you do
and
like
the decedent lots.
you do like the.
For parental and decedent lots. We just don't want to see everyone doing it because we're not sure. We can't
not
say for
sure,
certain
but we're
that
not
they
certain.
will do that. It's a risk decision. There's a risk if you go to covering the whole island in quarter-acre lots with these systems that if they may work, some of them may work, a percentage may work, may not work. You run the risk of exceeding those MCLs and then committing those huge amounts of public funds to mitigate that.
Well, I don't want to belabor this conversation, okay? And as far as what an existing system and how, we're not bringing it to standards. There's many times and many conversations about leakages, and I'm just concerned that what we're going to do is we're going to lay blame on a lot of the leakages on a system that we believe can work, give it an opportunity to work, but there are leakages already that are occurring.
I just want to reiterate again, Guam EPA has been advocating for this solution. The only difference now is this density question. That's it. You talk about leakages. A septic system leaks all the time. That's its design. Every single gallon you flush down that toilet goes into the groundwater.
Sure.
A sewer system is not supposed to leak.
It's
It
not.
may leak because there's problems, but that can be fixed. That has to be fixed. There's already court orders with the federal court to fix those. But the septic system is a permanent leak that you've installed in the system. Every single new septic system you put in the ground is a new source of wastewater to the groundwater, and that's where we have to be careful. That's the risk mitigation piece of it that I'm talking about. And again, to reiterate, we are not opposed to the original idea, which was to provide these, to allow these systems for the development of the quarter-acre parental and decedent lots, which addresses every single permit that we have on hold at Guam EPA right now. It was this late addition of the 1/6 acre lots and the addition of 1/4 acre lots for everyone that we are concerned with.
Okay. Well, you know, ma'am, I'm going to try to adhere to the time frame and everything, so I'll go ahead and
All right, thank you,
save my
Senator.
questions for later.
Thank you, Senator Blas. Senator Fisher. Senator Dueñas. I'm sorry, Senator Nicolas.
Thank you, Madam Chair. I support this measure. I think, my dad told me never to disparage somebody who's actually doing their job. And I've heard the things that happen, you know, with EPA and stuff being held up there, but you are doing your job. But I wish that our government was more responsive and more forward-looking and saying, you know, we have this problem with the dissidents and people who are unable to use their properties. Nothing burns me up more than having the government tell me what I can and cannot do with my property. However, I do understand the importance of protecting the aquifer and the water. So we're ultimately going to drink this water. But I wanted to ask a question. Why did they put it on this type of particular lot? Is there any reasoning behind that, ma'am?
So the discussion was, again, to address the disparity in the lot sizes for parental subdivisions and decedent lots, which is what, like Brian said, it has been working on since 2019. The solution, the mitigation measures that were in the original comments is to address only those minority of lots that are affected by the current law. So, you know, this bill, as it's written, opens it up to everybody, which then, you know, opens basically a Pandora's box. And I get the what ifs, right? The what ifs, you know, the projections, the models. Yeah, they may not happen because they're worst case scenarios. But let's say we pass this bill as it is right now, and what if we contaminate our groundwater? Then what? We sit before this body and we're going to have to answer why is there contamination to our groundwater? And I'm going to come back to this day or the day that it may or may not pass and say, the legislature voted on passing the bill as is. So, I mean, that's what we're trying to prevent. I mean, we're trying to address and we're trying to satisfy, you know, the intent, which was to, help those families affected by the subdivision law, and allow them to build on these already subdivided lots, right? That, like Brian said, are currently on hold. I'm a bleeding heart. I had probably a dozen homeowners that have already purchased property from realtors that are less than the required lot size, where they've obtained mortgages. They've already contracted with a contractor to build their home, and they come to us saying, "Well, you put a hold on my project." And we say, "Well, I'm sorry, but the law says your lot size is too small." And they're crying like, "Well, I've got a $500,000 mortgage already pending. What am I going to do?" And this law was supposed to address those homeowners, those minority homeowners, not to open it up to everybody. That's all I'm saying. You open this Pandora's box, and there are consequences.
Thank you, ma'am. So the solution is to have a sewer system.
Absolutely. We have said that if there is sewer available in the area, we can go down to 1/8 of an acre and build, multiple family dwellings, so long as it's sewered. That's never been an argument for Guam EPA. The issue is unsewered lots over the aquifer.
Okay, I'm just trying to understand this. I just walked in. And,
apologize.
My apologies for that. But so it's sewer. We need to provide a sewer system to this, and who does that? GWA. And
Yes, sir.
have we been collaborating with GWA to rectify that in some way?
I can't speak for GWA. I can't speak for their finances. I can't speak for, what it would cost to put in that infrastructure. But I know that Miguel Bordallo has said, we'd love to. This morning he said, we'd love to do that if we had the funding. And, putting in that infrastructure is not cheap. I think it's like $500 million to sewer, the northern part of Guam, or more than that. I mean, but, again, we're not in charge of their finances. We can't dictate to them what their priorities are, but I'm pretty sure that they want to sewer, the northern area of Guam.
Okay. Is anybody from GWA here? No? Nobody? Okay. Well, I support the measure. Like, again, I don't like it when the government tells people what they can and can't do with their property. I think it's a long time coming. Our people are in need of it. I think they've been producing waste somewhere else. Having it done over an aquifer is not really going to change anything. By the way, I think our population has reduced some since since the pandemic and more war. So I support the measure. I think this is a very important thing, and we need to give the landowners who are not made whole by this. So I think this is a right thing to do, and we got to figure out how to do it and get GWA in here, and let's get those sewer systems to the people who need it. I have nothing further, Madam.
Thank you, Senator. Speaker Terlahi.
Thank you, Madam Chair, and thank you to those who provided testimony so far and those who are planning to provide testimony. All right, so just to recap, current Guam law allows for the division of property. If there's sewer, you can divide your property smaller and you can into more lots, right? Or more, yeah, and you can divide a lot smaller and, if there's sewer available. What we're talking about today is just the law that says if there is no sewer available, then you can only divide your lot into a half acre. Minimum half acre, plus you have to have an approved septic tank, approved by the Guam EPA. That's current law. And we're going to, this law, there are some lots that have been divided into quarter acre by parental subdivision, and we have allowed that, or the Guam legislature in previous decades have allowed that exception to our current sewer law. For parental subdivisions only with a septic tank. And we are trying to expand that to court-ordered subdivisions, which are very similar to parental subdivisions. So I think we kind of had a consensus that court-ordered subdivisions, when it's like an estate and they're dividing your parents' property by probate, those are not considered by Guam EPA as parental subdivisions, so we were trying to make an exception to the law. That's what I've seen work on for the last maybe 4 years. And I want to thank you, Captain Burden and Guam EPA director and your previous directors for very diligent work. I think they wrote most of this bill. And I want to acknowledge that because I don't understand the hostility towards Guam EPA, who is protecting our waterlands, enforcing our laws, that we are at huge risk if our waterlands is contaminated, as they have predicted, based on current development, current exceptions to the sewer system, that we will contaminate our waterlands beyond, at great cost. We're going to pay it at the other end. So, of course, the solution is to sewer the whole northern part of Guam. That's one cost that we could adopt. Or continue with these exceptions and with the risk. And that's why you mean we're taking a huge risk in our current law already by allowing, exceptions for parental subdivisions and higher density, right? And we are considering whether to take on greater risk by allowing court-ordered subdivisions at 1/4 acre lots to also have septic tanks instead of sewer. Can you confirm, Guam EPA, that the septic tanks that they're proposing that be used are this type 4? Currently, the statute says type 2. This would allow type 4 septic tanks, or they have other definitions, not leaching, soil absorbing facilities, disposal systems, type 4 disposal systems. Does Guam EPA agree to the type 4?
Yes.
Okay, so we will expand from type 2 and we will now allow type 4. And type 4 is going to only protect us from 50% of the leachates, nitrates.
I think I would reword that to say that it provides 50% better treatment than a regular septic system. It reduces that nitrate by 50% over the traditional.
Okay, so type 4 is better than type 2. Perfect, that's what I thought. And, but even type 4, which is better than type 2, this says will protect us from a minimum of 50% of the total nitrogen in the system. Right? That's what you said by our exceptions are really only protecting us from 50%, and that's only of this one contaminant, right? Nitrogen. Not any, and it doesn't protect us from any of the other contaminants. That's, to me, what has changed in the last 4 years that we've been discussing this bill. I'm all for change from type 2 to type 4. I think we could get an easy consensus on that. Changing from only parental subdivisions to including court-ordered subdivisions, maybe, right? But what this bill is asking us to do is go even beyond all of that, and to, on top of all of that, allow for 1/6 acre subdivisions by anyone, and they don't need to hook up to sewer, and they only need to hook up to a type 4 or according to this bill, a type 2 septic tank. Is that correct? Am I reading that right?
It's 1/6 acre lots with a type 4 system only for parental and decedent lots only.
Okay.
1/4 with a type 4 for everybody else.
Okay, so 1/6 only for parental or court-ordered subdivisions, but it would allow an expansion of current law for everybody to divide their lots into 1/4 acre if they use that, at least the type 2 or type 2 or type 4. Oh, only type 4. Okay. Okay. So I think your concerns are very reasonable. They're very reasonable. If we're, that's a whole other question, right? And it's almost has nothing to do with parental versus court-ordered subdivisions, parity. It really has a lot to do with the amount of contaminants we're currently receiving that you say you can measure, you have measured, right? And you've seen an increase, and that your studies show clear correspondence between the density and the increase in the contaminants, and obviously increase in septic use versus sewer use is going to increase contaminants of all kinds. And what we're trying to do with our sewer system is to protect not just from these nitrogen levels, but also the other contaminants that have really been brought to our attention in the last 5 years, I would say. And GWA certainly has their hands full. I too wish they were here, although this bill is not about bringing sewer out to people. I want to commend the chairperson of this committee, because not only did she work on this bill about expanding from type 2 to type 4, expanding from parental to court-ordered subdivisions, but she also, in previous recent budget bills, increased a program very similar to what's proposed in here about we're going to give grants for sewage. This is to bring sewer out to these areas where these are the groundwater protection zones, the zones that WERI, Guam EPA, and that the government of Guam professionals have told us need the most protection. So we've tried in other ways to prioritize bringing sewer into those areas and making it affordable in as many ways as possible. I wanted to ask you a couple more questions. That one is, when you say, if the bill was enacted into law that the annual increase in wastewater loading to the aquifers will double for agricultural lots and triple for parental subdivisions and decedent properties, leading to contamination of our groundwater, such as to require treatment before use as potable water. When you say that, is that a hyperbolic theoretical calculations that has no basis in fact?
Can you direct me to which page you're looking at here? I'm not sure.
The part where you say doubling.
So it's just the comments on section 7, the
Yeah.
comment number 1? Again, it's just to repeat what we just discussed a few minutes ago. It's a doubling of wastewater loading. So if you've got 1,000 gallons a day going in from one home, and you've got 2 homes now, you have 2,000 gallons a day going into the aquifer. That's really what it is. It's just the amount of wastewater going in there. That's wastewater loading. Now, some of those contaminants may be different, because if you've got this advanced treatment system, you're reducing the nitrate, but some of those others are not. So that's what we're getting at.
Okay, so it would definitely double the, sorry, what's the term again? The
Wastewater loading.
Wastewater?
Wastewater loading.
Wastewater loading. It will increase the contamination, but it will not necessarily increase the nitrogen contamination?
It adds nitrogen.
It will.
It adds nitrogen at 50% less than it would be added with a regular septic system.
Okay.
Yeah, so everything you add to the groundwater, wastewater-wise, adds pollution.
Okay. And for EPA, does EPA need to create rules for the type 4 type of system, septic system?
Yes.
You need rules.
Yes, although the bill, as it's currently written, has an interim permitting authority, which allows us to release these permits that are held right now with some very bare bones rules that are in there. Those rules that are under that interim permitting authority would be then replaced once regulations are issued by Guam EPA, which would then be more detailed. That's the idea, anyway.
Okay, are there standards that you intend to use in creating these rules, such as US EPA has adopted type 4 or has not adopted it or has created some type of parameters for you to use?
Our main intention was to keep this as simple as possible, put as much on the market as we can by using the NSF 245 standard. So that takes away any kind of judgment from Guam EPA. As long as we see that NSF 245 approval, then we approve it to be used. So it seems bare bones, but it's also pretty well established in there. The regulations, when they come out, would probably just add more details as to how you would issue the annual permits and such, and maybe allow for a few other things, such as reduction of leaching field sizes and such.
Okay, and whose job would it be to inspect a facility suspected of leaking or not being installed properly or something like that?
So the idea in there is that to get an operating permit, a homeowner has to provide an operation and maintenance contract from a approved vendor. And this would usually be the vendor that sold the system. They would be manufacturer approved to service that system. And then to get that operating permit renewed, whether it's annual or some other time period, they would have to come in with a new contract and a brief report from that vendor saying whether there had been any trouble with that system and an inspection of that system to show that it's still running. So the idea again there is to put that workload onto the market and not onto the Guam EPA personnel, so other than just tracking that.
Okay. All right. I understand that. Thank you. Thank you again for all your work. Just to the Attorney General, can I just ask, a lot of your recommendations were changes to the language, so I have to study that more slowly, I guess. But if you could just tell us maybe in general, what is the purpose of these changes? What would it do to the bill?
I think mainly the purpose of the changes, Madam Speaker, were just for clarification to make sure that it's clear, that the definitions are clear, that just to add some, I mean, in general, Attorney General's in support of the bill, but just to make sure that there are clarifications and also that it's noted in this particular section that the Attorney General has the right of enforcement, right? You know, in case there's a violation, there's a notice of violation, it's not cured at the agency level, well, then the AG, at some point, if the violation continues, EPA should refer it over to the AG for enforcement, you know.
Was the current AG the AG when we were entered into the consent decree for the wastewater violations? I'm not sure.
I don't believe so, Madam Speaker.
I'm just curious because I'm curious if the AG's office is also tracking, our past violations, our current trends of increasing contamination, and whether we are at risk. That's my question. I wish GWA was here as well. All right, thank you. Thank you, Madam Chair.
Thank you, Speaker. Senator Barnett. Senator Tadegui. Yeah, I was just going down the line. Do you want to?
Okay, thank you. Thank you, Madam Chair. Thank you to this panel. Yeah, this is, I haven't made up my mind if I support the bill because, to be honest, I have a very basic, cursory layman's knowledge of all these issues we're talking about. But I know that when we say we're all genuinely concerned about our drinking water and protecting the environment, then I think that means that we then listen to the people that have the job of protecting our environment. And I'm just trying to piece this all together. So it sounds kind of like you guys had worked on a good bill with the previous senators, and you had something that you liked. And then the realtors kind of said, oh, half acre, no, let's do a quarter acre, 1/6 acre. And that's what's really presenting a lot of this testimony from you guys is you're concerned, and I'll go ahead and read it from your testimony here on page 4. Bill 175-37 goes far beyond what Guam EPA has suggested to allow for the development of quarter-acre lots for anyone within the GPZ, not just parental and dissident lot recipients, and 1/6 acre lots for parental and dissident lots. This would result, and I get it, I mean, you have a piece of chicken, you cut it into a bunch of little pieces, it's going to increase the wastewater loading. So I get it, but I'm just kind of curious, what do you think happened? We had something that you guys supported, and all of a sudden it kind of like transformed into something that you guys have major issues with.
I don't think we can speak to that. We don't know how that was changed.
I mean, I think it's pretty clear that we took this bill and we let the realtors kind of craft something that they wanted. And it's clear from the testimony, and with all due respect, I want to hear both sides. But I also want to apologize because I too don't understand the hostility here, and I really pray that we take all of this testimony to heart and we really keep in mind when we have subject matter experts in front of us that we take into consideration what they're saying. That kind of makes sense to me. And what I don't want to see is a situation where we pass a bill, you know, similar to a measure that we passed, where we allow for something, and then there's all these problems with it, there aren't any rules and regulations, and then we end up having to say, oh, well, we need to now pass a new law to fix the law that we just passed. And that's what I worry, because if you kind of look at who's supporting this and the tone of it, I worry that they have the votes and they're just going to mash it through without really being careful and considering the very real impact that you guys have stated on the record to our environment. And so I just apologize for that. I think that, you know, we have a responsibility to take in all of the information and then make up our minds. So I thank you for providing some very, this is some good information for me. And I'm going to, again, take this home, and it's going to be my bedtime story, all this testimony. So thank you for coming out, and thank you for providing that testimony. And, you know, hey, if you got to say no, say no. You know what I mean? I think that's fine, and I apologize again for that. I don't know where that came from, but, you know, you're the regulatory agency, and I think our island would be way worse if you guys just said yes all the time. So thank you for your testimony, and thank you, Madam Chair.
Thank you, Senator. Senator Tadegui.
Thank you, Madam Chair, and I have to echo the same sentiments of my colleague, Senator Barnett. You know, this almost looks like another fireworks bill, if you ask me. When you provided your testimony, Captain Bearden and Michelle, I noticed this morning when we had the public hearing, informational hearing, WERI provided some data and research, and it showed this massive purple area around a condensed group of housing, and then one where the housings were spread apart and was less purple but a light shade. So is your testimony based on WERI's research and data, or did you do this research and data on your own?
We collected quite a bit of information. The WERI data was used mostly as just confirmation that we would see the same distribution of nitrate underneath development as we see with real data in the CNMI, which we did use as something to look at as a model for Guam. Same geology, the only difference being that it's shallower.
Okay, because if I'm not mistaken, someone mentioned about this system. This several companies have this neutral nitrate system removal, I guess, but it's not full. It's only about 50%. Is that true?
The standard is 50%. Some of the manufacturers claim a larger percent, but the standard is 50%, and our opinion is that any policy decision should be based on the standard and not a particular manufacturer claim.
So technically, we're still building up nitrates, even though it's not completely gone, and we just brought the houses closer together, so it's basically not going to change the situation we are in today.
That's roughly correct, yeah. It's better than a septic system. It's 50% better in terms of its nitrate loading, but we're talking about doing 2 of these per half acre instead of 1, so you end up with the same nitrate loading but more wastewater.
Okay. Michelle, when you were talking about a section in the, you don't have the page, oh yeah, page 5 of your testimony, it said, it's worth noting that the majority of parental lots permitted over the past 2 years since Guam EPA has been tracking this data appear to have been developed by investors, not by individual homeowners. While Guam EPA supports efforts to promote the ability for individual homeowners to build on their family properties, developers should be held accountable to pay for the infrastructure that is required to protect public health and safety and is required what's required in other jurisdictions. Can you kind of break that down, that whole paragraph, and explain that?
So what we've seen, and this is through Captain Bearden's tracking, is that when these residential construction permits come to the agency for review, that a majority, if not 85% of these permit applications are not local residents building these homes. You know, and not to be racially insensitive, But a lot of the, the names and owners listed on the permit applications are foreign names. They're not local names, and that's 85%. So, there's the assumption that these are developers. We certainly have had instances where the same contractor will, down the line, would have purchased a property, and to circumvent the subdivision laws and requirements will build 1 or 2 homes, right? So that's not considered a subdivision. So they don't have to put in the infrastructure for, what he's proposing or what he's envisioning down the line, which is like a 15, 20 unit subdivision. And then, water, wastewater infrastructure is inadequate. So, and we've seen that. We've seen where a contractor or a developer has come in and built onesie twosies at a time, and then lo and behold, there's 10 units or 10 homes, which is a subdivision, and no infrastructure, and they're all on septic.
Are you familiar with the Gilbaza subdivision issue that happened?
Where the developer didn't put in the infrastructure as promised?
Right. And the people were suffering because of it.
Right. Well, and like I said, that we've seen instances like that where a developer has circumvented the subdivision law and requirements for the subdivision by, building 1 or 2 homes at a time. But in the long run, when we see the overall layout of the property, it's now a 15, 20 unit housing tract.
Michelle, how do you see, how will this policy be regulated, especially for existing systems? How do you see it being regulated? Who's going to oversee that?
So you're talking about existing septic tank, leaching field?
Yeah.
So we do. We oversee septic tank leaching field at construction. So
And
currently there isn't any, we don't have anything in place that would inspect on a regular basis, like these individual septic tank leaching fields for residential homes, we don't inspect them after they've been given the occupancy permit after construction.
Okay. Mr. Attorney General, there are prosecutorial measures of violations. Does Guam have the resources to carry out these penalties?
Well, I think it seems that the provisions of this bill at least put the provisions for penalties in there. I mean, it's obviously the first line of enforcement would start with Guam EPA, which may need additional staff. To help them with that.
Maybe or will be additional staff.
Well, I certainly can't speak for Guam EPA. Yeah. I'm certainly.
Okay. What about at the Attorney General's office?
Well, our position is that after, we would take the referrals from Guam EPA. If a notice of violation is not handled, and obviously if the owner doesn't correct it, then obviously at some point we have to take the owner to court to make sure that the violation is not continuing. And so that would be the responsibility of the Attorney General's office to handle those ones that are not handled or unable to be handled at the administrative level with Guam EPA.
Okay, thank you for that. And thank you, Madam Chair, for the opportunity, and I thank EPA for all the hard work you're doing. I know I gave you a hard time this morning. My intention was to just get information and data so that I can make a sound decision on this legislation. I appreciate the work and collaborative work you're doing with WERI, especially with WERI, and I hope that you also bring DOD in the mix, as we talked about this morning, to find out what they're doing over our waterlands in the northern part of our island. Thank you so much. Thank you.
Okay, thank you, Senator. I would like to thank the panel for your attendance here today and your participation. We look forward to any additional information and amendments that you can provide, and thank you for your work today. We'd like to call on the next group, so we can probably fit 10 people on this next panel. So I'll be calling in order of those that signed up. Gina Campos, Liz Dueñas, John Santos, Elaine Santos, Monty McDowell, Jody Dueñas, Monica Flores, We might be able to fit more. Neat Baza Munya, are you here? Peggy Lagas, is she here? Also Dorothea Santos Poe. Okay, these are the Zoom. We'll just wait for the second round. Let's see if there's any more here. Is there anyone else here that would like to testify about 175 that's present? Yeah, if you can come up for it. Did you sign in by any chance? Okay, can you sign in? Okay, so we'll go ahead and start. Gina Campos, you're recognized.
Thank you, Madam Chair. My name is Gina Campos, and I'm here in behalf of myself. I'm not representing the Guam Association. I'm just here as a concerned citizen. But I am here because in my line of work, I have come across some issues that have greatly concerned me. And I actually want to start, Madam Chair, by asking the senators, and you in particular, what is the difference in your mind between a parental subdivision and a decedent map? People who inherit their property through a decedent map. I need to understand what you believe the difference is.
Sorry, testimonies usually, it's, you have to provide the testimony. It's not a conversation at this point.
Well,
so,
I'll
yeah.
explain to you what I think it
Thank
is.
you.
A parental subdivision is property that you receive while your parents are alive. And the law is clear. The law says that if you divide property, this is existing law as it is right now. As a parent, I cannot divide my property more than into 5 lots. After that, it falls into the subdivision law. So I wanted to clarify some points that EPA made earlier. So it's 5 lots, period. As a decedent map, these families have gotten their property because their parents have passed. And they had to go to court, and through the court process and through a registered surveyor, and in some cases, the court does look into how many family members are still remaining, how big is the lot, and with the cooperation of the family members and the registered surveyor who is doing their work based on the law, they come up with a map to pass on these properties to the families. It could be more than 5 lots because in the past legislature, they allowed for this to take care of families. So it could be more than 5 lots. And the law, the court, it's called a court-ordered map because the judge signs off on this based on the judge's ability to understand and implement the law. And so people like Mr. Santos, he acquired his property through a decedent estate. And then if we go to another section of the law, there was, and this is where I have found, I can't wrap my head around this part. This is chapter 62 of the subdivision law. The exemption is 62104, and that exemption reads as follows. Decedent estates and parental subdivision property, Article 5 of this chapter, Article 5 pertains to utilities. And it says Article 5, and it's utilities and infrastructure in general. But Article 5 of this chapter shall not apply to land which is an asset of the estate of a decedent, provided, however, that before the distribution of any such land by the court, the territorial planner or commissioner may enter his or her or its appearance and require street utility easements on the land to ensure lot divisions consistent with the general plan with the provision. And it says Article 5 shall also not apply to land which has been owned in fee simple, but it basically says the exemptions are decedent and parental. It says that in the law right now. Some years ago, Land Management issued a letter, and this was, it was dated November 19th, and I think it's 2000, it's hard to read the date, but it basically says that it says revised Guam EPA minimum yard and lot area table. And this is where EPA took their interpretation that the lot size was to be determined by EPA. And this is basically what the letter said. Public Law 24-51 amends Section 61501 and adds new subsection B and C of Chapter 61, Title 21 GCA. The amendment and additions to this zoning law require all A, rural zone property located over the northern Guam soil resource aquifer to have equal lot sizes no less than 19,200 square feet or 1728 when public sewer is not available and only one dwelling is authorized per night per the 1728. And then it says, furthermore, when public sewer is available when the property is located, the lot size shall not be less than 9,600 square feet, 864 square meters. Subsection 61501 also provides Guam EPA's ultimate authority to establish lot sizes and setback requirement for all development over the northern aquifer. In reply to concerns of the Department of Land Management Chief Planner when he was reviewing a subdivision map for returned properties in Dos Amantes area, he came across a few lots not conforming to the lot sizes reflected on our minimum lot yard. Our Guam EPA planners have worked with him in formulating lot sizes to be applied to unzoned properties. And this is where the letter came from. I cannot believe that, and this morning when I was here at the hearing and listening to GWA and EPA, they made it clear that our water is contaminated to some degree. And it is not just contaminated by nitrates. This morning's hearing was pretty much about the chemicals that have gotten into our water system. And they could not definitively say, GWA and EPA both said, we cannot really pinpoint where these chemicals are penetrating into our water wells from. They said that this morning. There were 3 senators present in the room. Perhaps we all heard the same thing. There's no definitive answer that says it came from all the junkyards that have accumulated over illegal junkyards over the island, illegal dumping. They said it could be that. In the WERI documents that I've read about the water, it says it could come from the septic tanks for sure. It could come from busted sewer lines and old sewer systems for sure. It could come from vegetation, that was for sure. Livestock is for sure. And I mean, the report really pinpoints to a lot of contributions to the pollution. But what I have a problem with, and I'm sure all of you, if you understand what is, if you took the time to really understand what some of these families are going through, the only entity, the only body of people that the burden has been placed on them has been decedent estate landowners. Currently, even if their lot is a minimum of 929 square meters, which follows the parental lot, currently, they cannot get a building permit from EPA. That is the interpretation. I say it is EPA's current interpretation since 2019, because prior to that, there were no issues with obtaining a building permit if you are parental or a decedent estate owner. Prior to that, the interpretation was, yes, these 2 entities of people will be treated equally. If a parental person could get a building permit on 929 or greater, then so can a decedent estate landowner. That was the interpretation back then. Under new leadership and new management, that is no longer the interpretation. And okay, I understand maybe what we are working towards is a solution to fix this problem with nitrate. These septic tank systems, these new systems, it's only going to address nitrates. It's not going to address the pollution that's getting into our water from, I'm going to say God knows where, because that's basically what I heard this morning. It could be coming from many sources, and all I heard this morning is the data is not clear. We're studying the data. So I want to ask, why is it okay to put the burden only on decedent estates while we figure it out? Because I agree, we need to figure it out. And my other question is this: why are we not all aboard in getting Type 4 facilities implemented? And then I want to clarify one point for EPA. This will not be a free-for-all. The subdivision law is distinct from this bill and the parts of this bill that is being corrected in the law. The subdivision law says if you subdivide your property into more than 5 lots, we're no longer talking about the provisions that are addressed in this bill. It goes into another section of the law. So it's not a free-for-all. I want to just, I can understand their concerns, and it's a valid concern. But this is not what happens with this bill. Once you subdivide your property into more than 5 lots, that goes into another section of the law that this bill doesn't even touch. This bill is only saying for people who want to continue, who want to build on their property, and you're a decedent estate, which, by the way, that's a completely different issue because judges are in charge of that. It goes through the court system. So perhaps, the next thing we need to address is let's go talk to the judges. Why are you interpreting the law this way? That's a different conversation, a different problem. But I just want to promote the idea that we all be part of the solution and endorse this bill. And I want to give EPA some relief in knowing that this bill doesn't touch the part of the law that says once you're over 5 lots, we're having a different conversation. You have to follow the chapter 5. You have Article 5 of Chapter 62, the zoning law. So I just, I'm here to promote the idea that until this law goes into effect, people like Mr. Santos and other decedent landowners be allowed to build on their property if their lot is a 1/4 acre or more, because that's how it was done before. And I don't see why the burden is being placed only on them. Where's the penalty to GPA for not moving forward with the sewer lines? Where's the penalty to EPA for not clearing up all the illegal dumping that is contributing to all of this? Nobody else is being burdened except decedent family owners, and that's wrong. Thank you.
Thank you, Gina. Next on the list is Liz Dueñas. You're recognized.
Thank you, Madam Chair. I support this bill as it is a solution to add to the construction of homes to support our current shortage of homes for local families. I'm not here as a realtor, I'm here as an individual. Many families were denied permits, and many could not even get past the inquiry based on the size of their lots that were less than a 1/2 acre. As of today, parental subdivision lots are able to obtain permits, but not decedent lots that may be sitting side by side with a parental subdivided lot. The law needs to be corrected to fix this disparity. My concern is GEPA will eventually deny building permits for parental subdivisions eventually, and that's parental subdivided lots. I mean, I know there's already talk about that. Our local culture of passing land down to our children and future generations to get a running start on owning their own homes should be continued and protected. I am a product of parental subdivision, which allowed me to build my first home. Why are we going to not deny others to build their homes? It's not fair and it's not right. My parents gave 11 kids their lots, and it gave 11 kids a start. I really oppose the fact that we're going to deny our people the right to help their families. We are all genuinely concerned about our drinking water and protecting the resource for our families and our future generation. There has to be a balance and solution for all to live without denying people's property rights. The studies justifying denying permits have anomalies and do not have concrete evidence presented that our groundwater is being polluted to the degree of endangering our community. For every problem, there's a solution and different ways of handling things. The solution could be the nitrate system, or fixing our leaking sewer systems, and bringing sewer to the underdeveloped areas. Funding and bureaucracy may be the stumbling blocks in getting this done. So I ask each of you to give that some thought. Do not deny our people their rights. And if you had children, you want the best for them. And to deny them the right to build is totally wrong. Thank you.
Thank you, Liz. Next on the list is John Santos. You're recognized.
For the senators and members of this committee, thank you for having me. My name is John Santos, and I'm here to testify in favor of Bill 175-37. I am one of the many landowners who is being affected with the denial of building permit by EPA's current regulation. All the house lots that we inherited through probate are on top of the northern aquifer with no public sewer available and doesn't meet the area or land size required by EPA to build a standard septic tank and leaching field. At this time, all of our 13 lots are considered liability simply because the existing laws and regulations by EPA. However, EPA recommends and supports the use of Type 4 nitrate filtering system. EPA wants to make it possible for us, the public, to build on our properties, provided we utilize the Type 4 filtering system. None of my siblings or my plans and goal with our properties will ever materialize without the passage of this bill. This bill will protect our water sources. This bill will comply with EPA's regulations. This bill would make it possible for all affected landowners to build their most needed homes to live in. In closing, I would like to thank the author of this bill, Senator Chris Dueñas, and the co-sponsors, Senators Tom Fisher, Senator Dwayne, Nicolas, and Senator Frank Blas, and Senator Jesse Lujan. I also want to thank each and everyone for all the hard work, and I look forward to all your support in passing this bill. Thank you.
It's Dismasi. We have Elaine Santos. Next, we have Monty McDowell.
Thank you, Madam Chair and Senators. I'm not going to go down the same road that everybody else is. I'm in complete agreement with what's been said. I think that myself, Monty McDowell, as chairman of the Guam Association of Realtors Legislative Committee, need to step up to the plate and say a little something about the Guam Association of Realtors and their involvement and what we're really there for as a component, one of the committees of our real estate community. I am very much a community-oriented person. I run my business. I'm a principal broker of advanced management. I actually perform very little real estate. I'm Guam Association of Realtors 2023 Realtor of the Year. Out of 600 realtors I met. Why? Because of the community service that's performed by the legislative committee that I lead. I have surrounded myself with people like Chris Felix, John and Liz Dueñas, and a list of others that have the same attributes, same strong feeling of helping the community of Guam with issues that deal with real estate and their ability to enjoy the dream of home ownership. We get approached by the community because we are the people, the rubber meets the road when it comes to dirt, when it comes to real estate. In this case, we were approached by members of our community that have obtained their property through the court system, through what we're referring to today as decedent estates. And they are not allowed to enjoy home ownership because they received their land in that manner. But their counterparts who receive it in parishes subdivision do enjoy the joy of home ownership. And so there's a disparity. This isn't something we dreamed up. This is something that was brought to us. There's nobody here that's going to benefit from the real estate community. The people are going to benefit is Mr. Santos and the many, many Mr. Santos that are on this island that cannot and for years have been unable to obtain a building permit to enjoy home ownership. So I feel I have to say this because there seems to be a feeling here that the realtors are behind this for the benefit of the realtors. The realtors are not here to benefit. They're here to benefit the people of Guam so they can enjoy the dream, the absolute dream of home ownership. That's the end of my remarks. Thank you very much.
Thank you so much, Mr. McDowell. Next, we have Jody Dueñas. The next one is Monica Flores.
Hafa committee members, senators, and chairwoman. Thank you. My name is Monica Flores. I'm a member of Pertei Latexan Savertidian. And I was actually here since 9 o'clock this morning for the informational briefing for the status of the aquifer. Was hoping to give some comments then, but we ran out of time, and I'm here to, of course, testify on Bill 175. And I just want to point out to the page in the bill, page 6, which is part of Section 7E, where it says where there is a problem, because Guam EPA has permitted since 1997, has allowed the development of quarter-acre lots within the GPZ for parental lots only. But here's where you see the bad math. Here's where you see where it doesn't add up, right? Because this is where you see where the law allows for 6 of these type 4 septic tanks. And this is where you'll see where the Pandora's box opens, like Guam EPA was saying. Because this takes it from 1 to 2 to 4 per acre to up to 6, just by dividing the size of an acre by the number of 7,200 square feet that allows for up to 4. So that actually does not represent a decrease in the nitrate production. It actually represents a 50% increase per acre in every acre where it's allowed 6 units. If you have 6 units on an acre that produce 50% less nitrates with the type 4, there's still 2 units over the 4 that are permitted by law. So you're still producing at least 50% more nitrates, just based on this bill alone. At first glance, this is a really good bill. You know, a lot of us have been coming to the legislature for years now to talk about the aquifer. And I have to say that I've seen some of you over and over again listening to us talk about the aquifer. For a lot of you, this is the first time I've seen you. And some folks, you know, it's quite disturbing to hear, you know, some of the co-authors say things like they don't know enough about this issue to co-sponsor it, you know, when some of us have been looking at the vulnerability of the aquifer for years as, you know, concerned constituents. And, you know, to see some of the very authors of this bill, to know that some of them have undone some of the policies that protect us from water contamination, it just doesn't make sense. You know, one of the big issues that were brought up today was PFOS and PFAS contamination. And we heard GWA say that they have to store the filters for PFOS and PFAS contamination or ship them off island. What's really interesting is that, you know, the law to protect us from open detonation, which is a direct cause of PFAS contamination, was undone. And it was undone by one of the authors of this bill. And so if you're going to fight against water contamination, why not do it in a real holistic way? You know, nitrate pollution is a serious issue around the world. It's a costly environmental problem. It causes permanent damage to groundwater. And we have a sole source aquifer that provides the island 80 to 90% of the drinking water. This, you know, we don't have to look very far to see what permanent destruction to an aquifer looks like. We can just look at Saipan and see the numbers, see how much money they have to pay to get their people potable water, usable water. And we can look at Hawaii. We can look at all the water contamination in Hawaii. We can look at Vieques, Puerto Rico. And there were sources that were named this morning. Formerly used defense sites. Formerly used defense sites were sources of a lot of this contamination. You know, we can look at the algal blooms in our ocean. We know that, you know, there is a problem as well of illegal septic tanks here. And this bill does not address any of those existing problems. And we need to ask ourselves why it's taken so long to course correct this issue, either through permitting, grants, or otherwise. There's been no real attempt to get to the root causes that have brought real results. You know, the bill only goes so far as to ask Guam EPA to encourage consumers to change their systems. Furthermore, you know, this obligates the homeowners to buy the system, but they also have to sign a yearly maintenance contract. And we don't even know if our consumers will be able to afford this. And then where does that fall on when those septic tanks are not kept up? You know, while this may benefit a very small amount of our community members, a majority of us are going to suffer the consequences, and then we'll have to pay to correct, if it's even possible to correct, some of the destruction that's going to happen. Capital infrastructure projects are really the solution. Of course, the ideal situation would be for sewer to be around the whole island. That's the true answer here. You know, and for some people, there's just not enough money, there's just not enough time. But, you know, just because the vendor did the science doesn't make the science sound. We need to be cautious and not just jump to opportunism. If you really care about the aquifer, you have to stop the destructive practices from taking place and get things right. And don't sell out for the almighty dollar. And, you know, to come here to the legislature and hear lawmakers call people in the community names, call members of the government names, is really disappointing. We've got a lot of names, and we certainly don't show up here slinging those names around for the senators we don't agree with. Don't use the plight of the little people, okay? Don't use the plight of the little people to make, you know, potential profit for big business. That's definitely part of something that could happen here. You know, if we're talking about the dream of being a homeowner, I'm not a homeowner. I can't afford land here. We are being outpriced from our homeland because of the military expansion. If you really care about housing, if you really care about the aquifer, you have to look at the root causes. You have to address the root causes. And if you really care about type 4 septics, which GWA has been advocating for, which Guam EPA has been advocating for, you would write a law that does not exceed the safe amount of such septics right over an area that needs extra protection over our aquifer, over the GPZ. So again, it's simple math. An acre is 4,560 square feet. The bill says that the property area shall be a minimum of 7,200 square feet. That means that there could be 6 nitrate reducing systems in 1 acre, but that's not representative of a real reduction of nitrates if it increases the houses per acre. Thank you very much.
Thank you, Ms. Flores. Next, we have Chris Felix.
Thank you, Madam Chair, Speaker, the senators. Thank you for this. I it's kind of confusing where to start. There's been a lot of things said. I first wanted to clarify that I heard EPA state that they are accepting parental and descendant estates, but I know they're not. And you know, so I want to make that clear. They are not. For the last 6, 7 years, Gina, they have not, they refuse to accept decedent estate. 4 years, sorry. So, I mean, they've said they were accepting them. I'm telling you they're not. And I just want to make that clear. I don't mean to put them down, but if somebody walks in with it, they're refusing them. And we have witnesses and homeowners here.
Did you want to clarify that? Or, yeah.
Oh, I thought, I heard you say decedent and ancestral, but if I misunderstood, I apologize. Okay, but...
Yeah, I think I heard them say all the decedent subdivisions are on hold currently. They're not being allowed. They're on hold. Yes.
4 years they've been on hold. And the way I read the proposed law, and I may be reading it wrong, is first of all, the 7 units per acre, that's what's allowed now under parental and decedent estates only. It's not going to double anything. It's only parental subdivision, and decedent estates are allowed to do 5 or 6 per acre. All other subdivisions in the north is 20,000 square feet or 19,200 square feet. This proposes to allow those people to have 2 houses, to allow to subdivide it into 2. But if you the way I read this section of the law on page 5 is if they do that, they must put in a type 4 system in both the existing house they have and in any new house they build. So what they're going to do is they're going to cut their nitrate usage in half and then double it, so they're going to end up with exactly where they started. And that's what the law says, and that's the way I see it. If you cut the nitrate, if you use a 50% nitrate and you have to rip out the old one, put in a new one, and have 2 50% equal 100%. I may be wrong. And again, on all future, also what I read on page 6 is all future parental, and if decedents become allowed, those must be type 4 systems. So any new parental subdivision that EPA will allow will have 50% less nitrate usage. So it's actually, it seems to me, I don't know, but my math comes out, instead of doubling, it comes out equaling exactly what we have, or having it. A few quick things. I've been here 50 years. I work with developers, and I work with a lot of developers that come on island with septic systems, aeration tanks, and over the last 30, 40 years. And they go into EPA, and EPA, and I'm not current, this is 30 years ago, guys, but they come in and they say, oh, it sounds good, and they can't get the approvals needed. EPA says we're studying, we're thinking about it, so it goes on, and these guys then have to leave the island. And good systems we could have had, we've lost. Your bill says EPA the administrator can start issuing immediately, and then has 12 months to come up with the law. EPA is asking you to waive and forget the 12 months. My fear is if you drop the 12 months, you're never going to get approvals. I'm sorry. We got to hold someone's foot to the fire, and if this is a good bill, and if type 4 systems are good, then let's go. Let's do it. I'm very frustrated. There's been a little talk today about the system development charge. I was a director of the Chamber of Commerce 30 years ago when the system development charge was proposed. And I sat there and we fought it for 6, 8 months. And then finally we agreed, because they committed to take the system development charges, the $3,000 if you hook up water and the $4,000 for hooking up your sewer system, $7,000 each homeowner who builds a house has to pay. They're going to take that money, they're going to use it to give us new water lines and new sewer lines. That was their commitment. I was there, and I got their commitment. I found out about 3-4 years ago, Fred Arecki gives me a call, the attorney, and says, they've got $11 million sitting in the bank. The money just goes in there and nobody's touched it. And you know, so there's $11 million sitting in the bank for new sewer lines, and nobody knows what to do with it. Let's build new sewer lines. Because every time we connect one of these houses to a sewer, there's going to be less problems, less sewage problems. So why not pass a bill taking this $7,000 and giving it to somebody to do something with? Because it sure doesn't seem like GWA is doing anything with it. You know, the other thing is, you know, they're talking about doubling and you know, nothing stops someone like Starts from taking their 500 acres and cutting it up into 1,000 half-acre lots and then put houses on them. And then what will that do to our system? What will that do to our nitrate? What will that do to our groundwater system if someone does? Nothing will, right now they can do it. Somebody can buy a whole bunch of land and put half-acre lots and just build and put up regular septic tank leaching field. This law will at least force them to put the nitrate systems and cut our problems in half. So I just ask you to consider, please read the bill. That's the way I'm reading it. If I'm wrong, I apologize. But I don't see double. I see everything either remaining the same or actually lessening our groundwater nitrate system. Sorry, thank you.
All right, thank you, Mr. Felix. Next we have, if you can state your name, I don't have your name.
Hi, good afternoon. My name is David Damian. Good afternoon, Speaker Talahi, Chairwoman Perez, Chris Dueñas, Senator, co-sponsor senators, and members of the 37th Legislature and the people of Guam. Excuse me. I must say this is a very last-minute public hearing for me, at least preparation, that didn't offer much time and consideration for such an important topic. But none the least, I'm here and will offer what I can in support of on-site wastewater treatment systems being referred to as Type 4 systems in this bill. Again, my name is Dave Damian. I'm the owner of a company called CGSS that we formed back in, since 2009, I guess. I built my first duplex in Jigo back in 1995. Self-constructed my primary residence in Jigo back in 2001, and have continued doing other projects and helping provide shelter or homes for families through the years while working with wastewater projects, and that I did with Weary. And I believe food and shelter are some of the most important and most critical needs of our island and people. We've been studying and operating an on-site wastewater treatment Type 4 system since around late 2009, and installed a FujiClean Jocoso CE5 system after careful study and recommendations back in the year 2010. A total of at least 13 years we've been in operation. To give a little background, my father, David Damian, managed the wastewater department at the Public Utility Agency of Guam, now known as GWA, up until his retirement in 1992. And through my exposure, work, and discussions with him and other experts, did we determine at that time that on-site wastewater treatment systems will be a worthwhile project for our island and our people, considering the failures of the current systems to include the septic systems and also the centralized wastewater treatment system, which we know so much about, that continually deposits onto our land and our beautiful ocean. I know we all talk about, yeah, when we support the centralized treatment system, we're, yeah, dismissing the waste, but I don't know, I enjoy the ocean, and depositing it into the ocean is also not clean as well. But anyway, that's another topic. It was back in 2010 that we started with folks from the Guam EPA and WERI and traveled to Japan to complete an on-site study of FujiClean on-site wastewater treatment systems and to learn the installation and maintenance processes to bring back to Guam for pilot project testing and use. Following our return, Dom Sangil and I got the first system up and running on December 21st, 2010. Although we had another product and system on island to test as well, we settled with FujiClean as it is clearly a superior system. We have been in operation and testing with my family, my sister Anne-Marie, and brother-in-law John Cruz, and the WERI team, led by Dr. Rouse, who was a good friend, great, genuine man and professor, and wastewater expert that was collecting the data with me for the study until his very sad passing in 2019. Since then, we have been in light discussion with Dr. Habana, who did the thesis that I think we're all taking that report from, and I think some are taking things out of context or just taking what they want and not disclosing the rest, but anyway. And previously Dr. Jensen from WERI, in hopes of one day gaining some progress in improving our wastewater or our water treatment on Guam for the protection of our environment and help for our people. Our local team also included a wastewater treatment operator 1 and level 4 wastewater collection professional, John Blas, who has assisted from time to time in the maintenance of the system. Through the 13 years, we have learned a tremendous amount. First and foremost, I'd like you to take very critical note of the time frame and testing of the system of approximately, like we said, 13 years. Every day that goes by, we learn more about it. It is a system, and there are rules that must be followed in order for the system to attain the best quality of the effluent it can provide, but it can be done. Regarding installation, we have to follow an installation process that we learned and documented the installation steps, unlike probably what is being done today, which we did and provided to FujiClean Japan as well and to EPA. Every user that uses it must be educated and trained on how to use it and its restrictions and requirements, such as what can and cannot be deposited into it and maintenance schedule. Non-compliance can have effects, as we've all been talking about, and cause it to reduce the quality and cleanliness of the effluent, but again, can be done. Regarding maintenance in Japan, the requirement is that it must be maintained quarterly and pumped annually, so there is a cost to it. At the time of installation, it appeared capable that we could somewhat mirror the cost that is required for the maintenance, the cost of maintenance with that of the sewage fee bill we receive monthly. So what we were thinking is, or what we saw was, through the monthly payments, similar to what you're paying now for a sewage bill, you could take the same payment, pay it towards maintenance on these systems, and it would be about even. That's at the time when we first installed it. The only additional cost that we're looking at the time was the pumping out of the system annually, right? It was always our intention to ensure we test our system and the FujiClean company product before standing by it for use on Guam. And so after all these years, I can attest that it is a robust, excellent system. And the Fuji Clean company behind it is definitely one of the best and is making a great strides in the United States and leading the way. If any of you have ever gone to Japan, or if you've experienced what we've experienced, you'll see. If you go into the subdivisions, you'll see they use on-site treatment systems. And it's really, really interesting. I know somebody here mentioned, like in Japan, they truly take care of their environment. They use on-site treatment systems in very minimal sized lots. And the wastewater is actually deposited and transferred to rivers and streams. I think it was Senator Dueñas that was mentioning that. It's exactly right. That's exactly what we saw. The sewage water, which is also called effluent, that comes out of the system, it's so clean. Dr. Denton at Weary used to tell me, David, to give you a layman's term and explain to you how clean it is, go to your toilet after it's been flushed. And just think about it. The sewage water that comes out of your system is cleaner than that toilet water that's in your toilet. That was his explanation to me in layman terms. I took that, you can only take that literally, and it's because it looks like drinking water. You probably, when it comes out of the system, you wouldn't know if nobody told you that that was treated water, right? So just to give you a little bit of a visual of how clean it can be, right? And how, at least when you look at it. So it was always our intention to ensure that we test our system and the Fuji Clean company product before standing by it for use on Guam. So after all these years, I can attest that it is a robust and excellent system. Sorry, I'm repeating myself. But I'm not able to attest to any other system, obviously. And like the water meter scandal that Guam faced recently and experienced, I can only recommend that we test other makes before allowing it. I'm reminded regularly that just because it works in other countries and states, it does not mean it will work and survive on Guam. That was our position from the very beginning when we first started, and that's why we had no problem bringing it in, testing it. And we didn't go out there and claim and say, hey, let's do this right away, although we were working with EPA and WERI and others and hoped that we would have more support to do more tests. It didn't happen. So we are proud to have taken the time to study on-site wastewater treatment technologies, invest in it, and install it with our team and the Fuji Clean Japan company. More specifically, Mr. Shunya Kataya and Mr. Otoa, like Fuji Clean, we hope you senators would do your part to leave a beautiful and safe water environment for us, our families, our people, and our future generations. There is some work that might still be needed on this bill. However, I do support the use of on-site wastewater treatment system use on Guam, and thank Senator Dueñas and the co-sponsors, John and Liz Dueñas, and Gina Campos, and all here today. Thank you for your time and for listening. Thank you.
Okay, thank you so much, David. Is there anyone else that wanted to provide testimony? Oh, okay. Yeah, I didn't see you on the list. John Dueñas. Yeah.
I did sign in.
Okay. Yeah.
Okay. So I'm John Dueñas. I'm a realtor, but in my professional life, I'm a professional civil engineer with a master's degree in sanitary engineering. I was the chief engineer at the Department of Public Works from 1971 to 1976, and I've been a practicing consulting engineer since, actively. I am pleased to testify in support of the subject bill in its current form. I have here my testimony and language, but I will defer to the AG's office and as reviewed by the speaker to make sure that the language is clear and whatever enforcement requirements are necessary, that be clarified as well. As a representative of the Guam Association of Realtors, formerly as chairman of the legislative committee some time ago, and presently the vice chairman, Mr. McDowell, the chairman, I've been extensively involved since 2020 in the dialogue, discussion, with certain members of the legislature, legislative staff, as well as representatives of Guam EPA, Guam Waterworks regarding crafting legislation to recognize and legalize the use of nitrate-reducing individual wastewater treatment systems to address the development of unsewered properties over the Guam groundwater protection zone. I submit for your information and review Enclosure 1, which chronicles these discussions since the fall of 2020. I will go through it very quickly, point out the journey that we've been taking since 2020. Under the 35th Guam Legislature, September 20, introduction of Bill 404-35 by then Senator Bisco Lee brought this to the forefront. Basically, her bill was to remove the exemptions that were given to parental subdivisions and decedent estates. We made extensive testimony during the hearings on this bill. I worked with Guam EPA and Guam Waterworks to change the language to provide for the use of Type 4 systems. We had a bill ready to be introduced in the fall of December 2020, but Senator Bisco Lee chose not to run. The bill died. Fast forward to under the 36th Guam Legislature, nothing happened. However, in April 2022, in response to property development inquiries by Realtor Gina Campos, Guam EPA indicated that permits will not be approved unless a Type 4 nitrate-reducing system is used. Subsequently, Guam EPA indicated that such a system is not authorized by law and will not be allowed. So that was a checkmate. May 2022, the subject of reintroducing Bill 404 was brought up to the office of Senator Perez, Legislative Committee Chair dealing with environmental matters. The revised Bill 404 was discussed, but was scrapped by the Senator's office in favor of a more comprehensive change to the government code dealing with sewage disposal systems. June 2022 to September, GAR representatives and the office of Sabina Perez entered into a dialogue regarding a proposed new bill to deal with the authorization of Type 4 facilities. The dialogue involved Brian Bearden, Guam EPA, GAR representatives, myself, Gina Campos, Liz Dueñas, Senator Perez, and George Lujan, her Chief of Staff. September 2022, a draft bill acceptable to GAR was provided by George Lujan, her Chief of Staff. However, the dialogue ended because the Senator was preparing, you, Senator, were preparing to run for re-election and apparently did not have the time to introduce the appropriate legislation. Fast forward December 2022, you were re-elected. Congratulations. GAR reminded the Senator of the need to introduce the legislation, but was provided the excuse that the 36th Guam Legislature was no longer in session. Under the 37th Guam Legislature, GAR continued to pressure your office to take up the legislation. In February 2023, Liz Dueñas, GAR representative, contacted George Lujan for a status update. In response, Mr. Lujan indicated that the Senator's office was planning to meet with Guam EPA and GWA to discuss the issue. Safe to say that until today, there was no forward progress on the issue until Senator Chris Dueñas decided to sponsor the bill a few months ago, along with other senators. Some of them are here today. In every case, it has been solely through GAR's initiative and Senator Dueñas' benevolence that a Type 4 system is now being discussed. GEPA has been a reactive participant all along. Been dragging them all along. So, continuing my testimony. I wish to provide the response, or a response to the October 2nd, 2023 GEP letter to the Director of BBMR objecting to certain provisions of the bill. GEPA's concern that Section 7 of this proposed bill will lead to a significant degradation of the quality of our groundwater is somewhat disingenuous. When the agency continues to enact laws limiting the development of parental subdivisions, decedent estates, and agricultural subdivisions in unsewered areas within the GPZ, even with the requirement that a Type 4 system be used, but conveniently turns a blind eye. Now, please, Senators, listen to this. The fact that 1,800 Type 2 sewage disposal systems within close proximity to sewer continue to discharge into our aquifers day in and day out, their discharge, their wastewater, and supposedly increasing the nitrate concentrations that we find in our water wells. If reducing the discharge of contaminants to our groundwater is of primary importance, would it not be paramount that our government pursue connection of these systems to the public sewer system? Wouldn't that be a, rather than debating, doubling and tripling, why don't we connect those residences with Type 2 facilities to the sewer system? I've heard criticism that this kind of program was complicated. Yes, it is complicated and potentially very costly. At the same time, GEPA wants to warn us that severe contamination of our potable water systems produced, or our potable water producing aquifers, will require very expensive treatment of extracted water before use. If it was that important to protect the quality of our groundwater, wouldn't it seem to you like the first thing you ought to do is connect those Type 2 systems to the sewer lines that are, a lot of them are 50 feet away? Number two, GEPA asserts that if Bill 175 was enacted into law, that the annual increase in wastewater loading to the aquifers will double for agricultural lots, triple for parental subdivisions and decedent properties, leading to contamination of our groundwater, such as to require sometime in the future treatment before use as potable water. These analyses are based on hyperbolic, that was my analysis, to require treatment, these analyses are based on hyperbolic theoretical calculators that have no basis in fact. How are you going to double and triple? Where are you going to get the people to do that? We have 160,000 people, I don't know, about half, maybe a third live in southern Guam, so let's say 2/3. Are they going to be reproducing so much that, we could see doubling and tripling of wastewater loadings and within the Guam Water Protection Zone? There are a lot of factors that determine where houses are going to be built and how and when. And part of it is the birth rate. Part of it is migration into Guam. Part of it's our economic condition. How is this doubling and tripling a factor? The GEPA asserts the majority of parental lots permitted over the past 2 years appear to have been developed by investors. I heard some testimony about that. Can you back that up with some specifics? I want to know who they are. Who are these investors that are building 15, 20, 30 unit subdivisions without connecting to sewer? I believe Gina pointed out, once you go by the 5-lot parceling requirement, you enter into a new requirement. It's called the subdivision law. You have to go to the Planning Commission, submit your maps, they review it. You go on from there, whether you're allowed to actually build the subdivision or revise your subdivision, whether you're required to put in sewer. Yes, putting in public sewers is the answer. That's not going to happen overnight, but it will happen eventually. Finally, GPA objects to the 12-month timetable for developing regulations governing the use of Type 4 systems and would like the timetable basically to be indefinite. Based on my experience, formerly as Chief Engineer of DPW, I've gone through the AAA process a number of times when I was there, and as a practicing professional civil engineer over the past 47 years, I am of the opinion that 9 months is more than sufficient time to establish these regulations through the AAA process. And the additional 3 months, the 12-month limit, will serve as a buffer if Guam EPA should somehow falter in their enacting or development of these regulations. And finally, if the current GPA leadership does not believe that this can be done, by God, change the leadership, because it can be done. Finally, I urge you to pass the bill in its current form as soon as practical. Thank you.
Thank you so much, Mr. Dueñas. So is there anyone else that would like to testify that hasn't? Okay, so we're going to open up the floor for questions. I think, I know we have a lot of people on Zoom, I believe. Okay, so maybe we can just really quickly, if there's any questions for this panel. Senator Dueñas.
Tidus Masi, Madam Chair. Real quick statement. I find it laughable, the righteous indignation from some of my colleagues trying to mistake my passionate advocacy for calling names. They're some of the loudest individuals in this legislature, so I take exception to that. My question to you, John, is I want you to verify the meeting we had on September 1st with EPA and all the other representatives that were there, that the only thing at that time in dispute was the lot size. Can you affirm that?
Yes, I believe that they objected to the 7,200 minimum requirement for parental subdivision lots, which is referred to now as 1/6 acre. I don't know how many parental subdivisions out there are 7,200 square feet. I suspect most of them are a 1/4 acre or larger. I don't know, I like to see statistics that we're going to have 1/6 acre lots when this bill passes. I don't see how that's going to happen. And yes, we're concerned about the lot sizes because of the 1/2 acre lot requirement, the 1/4 acre lot requirement. Yes, that was basically the difference that sums up the differences we had discussing the bill, but now there are other issues, apparently.
Also, thank you, and I think Chris Felix is completely right on. The discussion here on the 1/2 acre going to 1/4 is, but it would double the systems. It would take 2 nitrate systems now and place it on something that would have otherwise been a 1/2 acre with 1 traditional septic system. Do you see it that way as well?
Asking me?
Yes, sir.
Yeah. Yes, I do, but, you know, again, if you can imagine that all of a sudden you're going to have all these lots which are going to have houses built on them proliferating in northern Guam because of this bill, I don't know. I just don't see that happening. I'd like to talk to someone who can tell us that, are we growing people out of the ground? I mean, it's our birth rate here. It's like when you build a subdivision up north, where are you going to get the people to live in there? From the people that are here. And we have 160,000 people. We're not going to have 500,000 people that all of a sudden they're going to end up populating all these lots and discharging, if they're over the unsewered areas, into our aquifers.
And I'm a passionate advocate, not screaming at people or calling people names, because I've had Mr. Santos in my office and other people like him and his family who's on Zoom. I'm hoping they don't come to tears because that's happened to me. And I guess other senators have not had these people in their offices with their hands in their face, crying. Like I'm going to read a testimony from another individual here who, yes, has a mortgage on a lot over a quarter-acre lot size, and only came to find out they were denied after having secured all the other permitting coming up to that. And now they're sitting there with a $500,000 loan that they're going to have to service and not be able to build a home. It's a crime.
Senator, if you hear Mr. Santos' story, and maybe he can tell it, how he had this property in Chalampago, he subdivided it, he did have half-acre lots. However, some trail turned into a road that went through his property, and they told him he had to sever it. And of course, yeah, I don't know, he went through some legal discussions, and finally, he actually severed a part of his property, or their property, their family property, so that the access that were being used by people illegally over his lot could be legal. The government turns around and tells him, oh, I'm sorry, you don't have a half-acre lot now, or half-acre lots. Sorry, you can't build. That, to me, that's, I don't know, that's government run amok.
Yeah, that's government not only not doing its job,
correct,
but becoming criminal against the landowner. Thank you, Madam Chair. Yeah, you wanted to say something, Gina?
Senator, can I just point out, the way this law is written, if you actually compare it to the existing law for parental and decedent estates, it doesn't change that. It just adds the type 4 facilities so that we can modernize our septic tank system. But if you take it and you compare it with the existing law, it doesn't change the existing law. It mirrors the existing law. So if we don't have, you know, the only time you're going to have 7,200 square feet lot sizes is when the court is involved and a registered surveyor and the judge have agreed that based on the law, we can go down to 7,200 because perhaps the heirs, you know, they do it to accommodate the number of people that are part of the estate. And that's the only time. In a parental, I've not seen registered surveyors go below 929. That is their practice. On a parental, they do 929. I wish we had invited some of the surveyors here. And they're following the law, might I add.
Yeah. Chris Felix, you got something to say?
Just also, if you're not familiar with parental subdivision, the people who receive that cannot sell it for 5 years, or 7, I think it's 5. So you can't have developers. Developers can't be involved. It's only for the local, for parental subdivisions, and they can't sell it. So the statement that there's developers involved in 7,200-foot lots, I don't see that.
Thank you for the chronological order, John, because the reason why I'm not taking credit for this bill, Captain, or anybody else, I'm taking credit for your work, is because nobody else would introduce it. So thank you for coming to me because I was willing to. Thank you, Madam Chair.
Okay, thank you, Senator Dueñas. Senator Frank Blas, Jr., you're recognized.
Thank you, Madam Chair. Well, once again, thank you very much. That was a great lesson in real estate and how to be able to break things down. You know, Dave, I have a question for you. You said you've got your system, the Type 4 system, in place since 2009?
That's correct there, Senator.
You haven't had any problems with it, any concerns?
No, as a matter of fact, that's why I come out here today. Prior to I guess deciding if I would, I mean, one of the main things that had to happen for us as a family was the system would have to work. It would have to at least work for us. Relative to the testing and the results and all of that, that's Weary. That's what Weary was testing. But for the operation, how it worked, the convenience, somewhat of the it's basically transparent. It's not much different, at least for the owner, because, or at least for our family, because obviously we do the maintenance, so they didn't have to be paying the bill and all that, but we've been doing it for 13 years. But relative to the usage, it's been very similar to septic tanks and leaching fields, I can say. Despite there being rules, right, I can just say that the family, our family is just, we're aware of how to use your septic system, what you can deposit into it and not, right? We do know that maybe some others would put other things into their system, maybe chlorine bleach or, you know, at huge amounts, but no, we haven't had any issues with it. We've done continuous maintenance. We've actually also gone through some, what we called at the time, stress tests. We wanted to see what would happen if we didn't do any maintenance, right? Dr. Rouse would always say, well, the only difference is it's going to turn into somewhat of a septic tank. I know that there's other discussion here saying, yeah, it's going to be worse than a septic tank. Well, I'm not too sure how that's going to happen, but okay. So let's just say that you have now, because septic systems, basically you're separating sludge and you're separating water, right? The raw sewage, the raw effluent is still going into the ground, but he would always tell me that the filtration system on this island is absolutely amazing. Handling leaching of water at minimal amounts, like from leaching fields, is, at least when we're talking about it, it's very controllable. It's probably far less of a risk than, and this is a whole other topic, but I think it would be wrong of me if I don't bring it up, because as I mentioned, my father was a wastewater manager at GWA. You know, he was the operations guy. He saw all the faults of our sewage system at the time, and interestingly, we're still going through experiencing the same issues. My family, the Dueñas family, are from Sinahanya. We used to get boil water notices in Sinahanya. Well, those boil water notices still go on today, and when that happens, we know it didn't come from the septic tanks and leaching fields. Although we continue to point at the septic tank leaching fields, I respect, you know, I guess the comments that are coming from EPA and so forth, but I must say, we all know the sewer lines are leaking at far greater volumes. You're talking by millions of gallons at a time. I can bring up videos if you like. We have people within the operations department of GWA. I recommend, encourage all of you to call them. Bring them into your office, talk to them about the sewer system. I'm not saying that it can't be fixed, but we know that they were all installed back in the maybe 50s, 60s, 70s. They used asbestos piping. They've used different types of piping that have been eroding throughout the years. The example that I think some of us would use is when we drive through Agana, we've known in the past and through ASEN, I remember my friends, the operations would tell me, when the road collapsed on Marine Drive, people were thinking, okay, it's a sinkhole or there's something. Well, it wasn't a sinkhole. It was a sewer line. The sewer line and the sewage is running through the earth with no pipe. Well, where do you think that sewage is going? It's not just staying there. It's leaking at far greater amounts than your septic tank and leaching field. So I take it, quite, I don't say insultingly, but I stay in Jigo, and they constantly make it very difficult for us when we're going to build, we're going to do anything. We've been affected by the constraints of development in the area since I started, as I mentioned, since I built my first unit in 1995. Up until this day, they constantly point at the septic tank leaching fields. But my father, who was a wastewater manager, would come home and it was different, right? As I mentioned, you got the Chaut, you got Mamahana, you got Jigo pump stations that overflow by millions of gallons. Again, I'm not an expert in it, but when you just think about it from layman's terms, if I put drops of water on the carpet, right, and it's going to go down, which one is going to percolate further down? Like drops of water for like as a leaching field, or we're talking about pitchers of water on a concentrated area like that of a sewer line. Again, I'm not the expert. I've worked with experts. They've shared the same concerns my father has, but we constantly keep pointing at septic tanks, leaching fields, and like I said, it actually is disturbing. It's terribly disturbing, because also And then, and again, we're looking at Dr. Habana's thesis. I worked with Dr. Habana, and they're pointing at, okay, the nitrates are rising in these areas. And I remember during the last testimony, the nitrates are rising in this area, which is predominantly septic tanks and leaching fields. But did we disclose the fact that the other areas that are predominantly all sewer lines? No, we didn't. It's like, no, let's just show that in the area where it's predominantly septic and leaching field, there's a rise in nitrates. But let's not show the other areas. And I encourage you to ask him yourself. Look at the report. Look at the study. So again, I know I'm going on and on, but it's been a long 13 years. This is our island. It's been a concern from, I mean, just our family since I can remember. The sewage system is not the best thing since sliced bread. The other topic to remember, Fukushima earthquake. What happened when the earthquake hit Fukushima? We all remember the nuclear power plant that collapsed in the ocean. We got nuclear waste. But what happened on the land side, on the sewer side? There's a seismic area, the sewer lines collapsed, and what happened? It contaminated the entire prefecture, right? What happened to the on-site treatment systems? Well, from my report, less than 3% were affected. So before we start saying, let's just do the sewer line and expand it and all that, and again, it's just my opinion, it's what I've been learning, we need to be careful about putting everything that we got into one basket. Until we can actually show that the sewer lines will, I guess, sustain itself if we have a massive earthquake. Was everyone here during the 8.3 magnitude earthquake that we had? Well, I can almost guess, I'm sure we have quite a bit of leakage throughout the island. I mean, I can go on with studies and talks about, you know, that we have as a family and as, you know, with also people within GWA operations, people till this day, right, about the downfall and about the failures of our current system. So that could be, and I guess I should just end it with this, that could be the actual culprit raising the nitrates on this island. But we keep pointing at septic tanks and leaching fields. And I think it's the reason why is because it's all pointing right back, possibly, to sewer lines. Again, I encourage you, you know, to study, ask questions. If you have any questions, I'm always available to share and to bring people to your doors so that you can talk to people in the field, people that can share firsthand experience, what's actually going out there. Reports that are being made with overflow of sewage into our Agana Bay, right? Reported to the environment, but nothing ever happens. Pump stations overflowing in Chalampago onto the roadside. Nothing ever happens. Nobody knows. I actually asked the question in a previous meeting. Why don't the people of Guam know this? They don't know about the sewer lines, but we constantly, lately, we keep talking about septic tanks and leaching fields. It's a bit disturbing, like I said, but again, that's where I stand. And I'm just sharing what I know and what I've learned. Thank you.
Can I just add to that very quickly? Sure. Senator? I know there's a lot of scrutiny on parental subdivisions and decedent estates and regular agricultural subdivisions, but have the senators considered what happens on Chamorro Land Trust lots? I mean, do these people build houses there? Very rarely. What happens? I mean, do they go home and use the restroom at home and then come back? Where do they do when nature calls, what do they do?
I think if you can recall my previous questioning about the pigs and the chickens and the cows. Okay?
Exactly.
But you're absolutely right, and one of the things that I also want to bring up is while we talked about the size of the lots and a lot of it over the aquifer, if I remember correctly in the previous event to be able to roll the bill out, there was a discussion too that just so the listening public and the watching public knows this is not just for lots that are up north. These are for lots throughout the island. You know, for individuals who've got lots in Iha, you know, or, you know, along in the southern area where not only do you not have a sewer line, but you just don't have the pump to be able to go up and down those, okay? To be able to do these things. So I appreciate it. But, you know, so I appreciate it. So Dave, the reason why I'm asking you about how long this has been, okay? While we're talking about new technology, you've actually had it since 2009. You have it in an abode, in a house, in a domicile that has already passed all the inspections. You live legally in this home with this system legally put together, and it's caused no legal problems.
None.
Okay, that's what I appreciate.
It was actually, at one point in time, it was really being recommended by EPA.
Yeah.
At some point, of course, we shared at the time, okay, there's a system, so what do you think? Let's do a pilot project together. Let's do it with Weary. Let's all do this pilot project and see if we can bring this in. This is actually installed in 2010. And, but nothing ever came about. Again, Japan, I think, is a great example. I was very, very impressed. Again, not the expert, but it's clear as day. It's very easy to see. You got treated sewage running through. They call them. They're just they're not enclosed pipe. They're just open culverts running through rivers and streams that are right by the subdivision. That's how clean the effluent it comes. So again, I'm not the expert when they start talking about PFAS and nitrates and all of the like. I enjoyed conversation with Dr. Ross. I miss it. It's been like more than 4 or 5 years since he's passed. I never intended to be the expert in that regard. That's why we work with the experts. But it's fascinating. My whole goal is let's do something that's going to protect our environment and not, I don't know, sometimes I wonder, right? It's like, is it to increase the flow to our treatment systems? I mean, always wonder, right? What's actually the reason why they constantly point at septic tanks, leaching fields?
Okay. Appreciate it. Yeah. Okay. And one last thing, Dave. I'll take bottled water when I come to your house. No offense. Okay.
Hey, thank you. Actually, I can use one now.
Senator Blas, I just want to point out that EPA made, when I had gone to meet with Captain Bearden about particularly John Santos's situation, he did recommend the Type 4 facility, and I said, oh, that's great news. I'm sure anyone building on his lots would put that in. And he said, well, it's not legally in place yet. That stops with all of you. EPA can't write laws, they can't implement laws, they can't put this law into the books. All of you have that responsibility, and that's why we're here. We're praying that you will see the need to upgrade our system and add the Type 4 into the books. No matter what else you think about decedent estates or parental, the thing is we have to modernize our system when it comes to the septic tanks. And that was the point that he was trying to make when I went in. And yeah, I am promoting the system, but I don't write the laws. You guys do.
No, I agree with you. And I think, again, going past a lot of the discussion about lot size here and where it's at, I think more importantly is we're providing the opportunity for technology that can be placed in a home. So it can be, you know, there's this whole drive and this whole thing to go self-sufficient, you know, in power and whatnot. Okay, why don't we do that the same thing with our wastewater and sewer system? Okay, so I appreciate it. Thank you very much. Thank you, Mr. Santos. Thank you very much too. Okay, thank you. Thank you, Madam Chair.
All right, thank you, Senator. Senator Fisher.
Thank you very much. Ms. Campos, if I could ask a question of you. In your opinion, is there a shortage of affordable housing on Guam?
It makes me want to cry. Yes, there is.
Okay. And what is the median home price on Guam?
Right now, you're lucky if you can pick something up at a decent home for $400,000, which, if you look at the current interest rates, you're talking about $2,900 of a mortgage payment. Is that affordable to anybody? So my position is this: for For those of us who believe being an investor or a developer is a bad thing, we cannot all afford to build. We cannot all afford to own our own home. We need those developers and investors to develop on our island so the rest of the community who can't afford to pay a mortgage payment have a decent home. And if we make it easier for these developers or investors, they're not going to build that home on Guam and take it and ship it somewhere else. Our people get to live in it. And if you're on this island, you are our people. I don't care where you started. If you're here paying taxes, you're our people already.
Thank you for that answer. And I believe I know, I think this is correct, that if you wanted to purchase a $400,000 home, the bank's going to want you to put 20% down. That's $80,000. And I'm wondering, you think about the hypothetical young couple, they've just been married a couple years, and maybe they've got a baby, and they'd like to build a house or buy a house, and how are they going to assemble $80,000, much less afford the mortgage? I think they're just going to leave island. They want to build a life. And it's no choice of theirs. They're just going to have to because we don't have the affordable housing. So my next question, Ms. Campos or Ms. Dueñas, do you think this bill will help increase the inventory of housing on Guam?
I think this bill will help Mr. Santos build the home that he wants, and other people that were denied their building permits, that they can build as well. So I don't know why the criticism is about the little people. We're all here. We're all here to survive, and we're all here working, and Mr. Santos and all the other Mr. Santoses will be given the opportunity to build. Why deny them? I mean, that's how I started. Why are we going to deny others for them to build and start their lives? It's our culture. That's what we're here about.
Do you agree, Ms. Campos?
Well, my opinion is this bill really addresses parental and decedent estates. That's not the bulk of our market. So I don't believe this is going to contribute tremendously to increase housing, affordable housing. That's not, these properties, that's not what they're geared for.
Do you think it might?
But it'll be a very small trickle, but it's not the bulk of what we should be concentrating on if the goal is to promote the idea of affordable housing. This is not it. This is just really to help individual landowners and families per se. I know EPA has been looking at all these foreign names that are doing parental subdivisions. They're still parents. They may have a foreign name, but they are still parents. Yes, they're using the law, perhaps not the way it was originally intended, but it's still being followed. But no, this isn't going to it's not going to make a huge impact.
Well, maybe not on the affordable housing. I understand that. Do you think it may encourage people who wish to stay on Guam to stay home here?
I think it's going to help. Every little thing that the legislature does to make it easier for people to build on their land or develop their land is going to help. It certainly isn't going to hurt.
Yeah.
But if the legislature really wants to make an impact in affordable housing, then we'd love to come back and have a different conversation. This is going to help, but it's not the focus. I have to tell you, getting a building permit here is like brain surgery.
Yeah.
It is so difficult that's what discourages everybody that calls me and says, Gina, I want to buy a house. And I'm like, tell me a little bit about yourself. And then I find out they own land. And then I find out the land is buildable. And then I'm like, why are you calling me to buy a house when you could just build? And then they explain to me how difficult, they're at the end of the journey and they've decided we can't deal with that anymore. We've lost all faith in the system. We don't have any more time. We just want to cry. Just find us something we could afford. And I have to tell you, Liz and I are big promoters of the idea of, okay, you know what? You come and sit down with us and we're going to show you how to do it, but how to build on your own land. It is going to take you a lot of time. I agree. But at the end, it's going to be worth the effort. We're promoters of that. But imagine if we could sit in front of you guys and explain all the problems that these landowners have with building, and you guys can make a difference there. Do you know why it's important? John is saying, you know, tell EPA they have to do the guidelines, the procedures within 12 months. Everybody should have a timeline. If I can't do my job in 12 months, I reckon my broker, John, would say, you're out of here, girl. You can't do your job in 12 months. Get out of here. That's the way it should be. And I'm saying, you know, if these agencies can't figure out a way to make it more friendly for building permits, that's where you really need to go. If you're concerned about affordable housing, make it easier.
Okay, well, the point well taken, and I think you won't find any disagreement on this panel, I think. Ms. Dueñas, you've been in the real estate industry for some time?
Yes, close to 30 years.
30 years. Is it true that home ownership is an economic driver for an economy?
Home ownership pretty much helps stabilizes a family. And yes, home ownership helps our economy as well. I mean, on this island, our economy is kind of like an imbalance right now, and you heard from one testimony that she doesn't even own land right now.
Yeah.
But everyone has an opportunity to buy. We've had people who would pay down payments and do payment over time to acquire property just to make it possible.
But is it also true that home ownership is an economic engine in the sense that if I build or buy a new home, I may need to buy furniture for the home, I may need to buy a refrigerator, I may need to buy carpet, I may need to buy window blinds, etc., and so forth and so on. All of that is creating economic activity. Is that true?
That's true, yes. And there, remember the program we had where there was government assistance for families to put a down payment? Then they had to go out and buy furniture, buy whatever's needed. They contributed to the taxes, their property taxes. They contributed in many different ways. So it's a ripple effect.
Yeah, home ownership is good
Yes.
for the island, it's good for the economy. This bill is good for the island. This bill is good for the economy. I'm proud to be a part of it, and thank you, Senator Dueñas. Thank you, ma'am.
Thank you, Senator Fisher. I guess my turn. Yeah, so I think, you know, what really the challenge is, I know we've worked on this bill together, you know, for me the challenge was how can we protect our water resource. I think, you know, considering, you know, the density is one of the main ways that we control the nitrate levels at this point. I think we're all in agreement. We agree with nitrate reduction systems. We agree with connecting with sewer. I think we all agree with that. And I think maybe, you know, looking at the language for density is that's where the difficulty lies. I think too that, you know, the aquifer, as we know from this morning, is very complex, right? And to me, you know, what I've read about communities that are sustainable from, you know, millennia ago, what works, a common element that works is that they all take part in, I suppose, their impact. And so this idea that was brought up in our discussions before was, you know, as we put on sewer, you know, if we connect people on sewer, maybe we can entertain, you know, these on-site disposal systems, so that what we're looking at truly is the effect on the aquifer, the impact in the aquifer. That should be, I feel, like the driving force in a lot of, you know, these approvals. You know, I think water is something that we take for granted here on this island because there's so much of it. And, you know, Guam is truly blessed, right? We are fortunate to have this geology that developed this abundant, this aquifer that can hold abundant water resource. And, you know, this took millennia outside of human intervention. And I think we need to stay true to that to protect it. And I feel like we are we want the same things. It's just maybe where we depart from is where the difficulty lies. But, I know I appreciate all of you for your endurance. And I think, living on Guam, this is something that this is part of our culture, I think, is we have to really endure a lot of things. But I do truly believe that we, at some point, can come to some agreement that we can protect our water and we can allow, development to occur. And I think that's what the difficulty is for, when it comes to environmental protections. There's this belief that the economics is always in opposition to the environmental protections. But I have this optimism that we can combine those two. And I've seen Bill Gates, for instance, I've seen his systems and I think they're pretty interesting, right? He's able to develop these on-site disposal systems. And in Africa, these places that really have a problem with sewage treatment. So, I'm keeping an open mind and I'm really pushing for sewage connections as well. So I think, we are getting there. But at the same time, I think we have to exercise caution whenever it comes to the aquifer, because we don't know everything about the system. It's heterogeneous. Unfortunately, we're hearing a lot of negative impacts. So I appreciate every one of you coming out today. But in regards to, some of the things that other places are doing, I think we can look at the model practices, like for instance, Palau, for instance. I think what has helped is that they've identified key areas that they want to protect, and they developed like an overall holistic approach to development so that they protect their environment. And it's my hope that we can, that's why we brought in BSP, we brought in other agency representatives this morning to really try to push for that collaborative effort to make sure that, the water that's being produced is also being, there's a comprehensive plan as far as the watershed management around the water resource. So, that's what I would like to say at this point. But also, this idea that, what is the cause of nitrate increases in our water? Yes, they're all causes, right? There's the, runoff, sewage runoff, whether it's from a broken main or whether it's from a septic tank or fertilizers. All of these are sources. But the one thing that keeps me grounded is this idea of the tragedy of the commons, right? If we don't really take responsibility for our individual impacts, it could lead to that. And we don't want that to happen for something so valuable. Can you imagine if our water resources is contaminated, we'd have to ship water, which we do, but or desalinate, which really would make Guam, life on Guam unsustainable. So I feel that we have that common goal. I just want to believe that we have that common interest in protecting this resource. And again, yeah, we need to continue to work together. So thank you.
Senator Perez,
yes.
I'm sorry. I just wanted to make a comment. You said that as you connect to sewer, then you could look at the nitrate systems, but that's something that is not in any citizen's control. And so if that's your position, that you want to see sewer lines being put in place, and then as those sewer lines are put in place, then perhaps you'd be on board with installing these new type 4 facilities so people could develop their land. The problem is the citizens can't control that. GWA had a plan where every 5 years they're going to build so much. They haven't even started anything. The system development fee has been sitting there. Citizens are paying into it, and that hasn't been utilized to do anything. This morning, GWA, when you were asking the question about when is the water system, when are these wells going to be treated, they said perhaps in 3 years. Perhaps, not absolutely. We're looking at doing this over a 3-year time frame. And I just want to say, to infringe on citizens' rights to develop their property while we wait for the government to act, that might not be a balance there, because we cannot control the actions of our government. So please think about that, because these nitrate systems, it modernizes what we have currently. It doesn't take away from it, it enhances it. And I agree with you, we all need to work together. Perhaps the community also needs to step up and hold GWA accountable for not acting in a proper timeline. I agree with you there. But to say that you perhaps can't see the use of these systems until more sewer lines are in place, that's a conversation with GWA, but to hold our rights hostage over that, I don't think would be fair, but yeah. Thank you.
Appreciate that comment, because I wanted to clarify it, because the idea is that if we have a way to monitor, so for instance, we need to identify these places, first of all, that are impacted, which they have, but the concept that I was trying to convey is that if we use the aquifer contamination level as our response, or I guess the indicator of how to develop, I don't know if that makes any sense. So it's more like a feedback system. So we're basically using the response of the aquifer as our feedback system, or identifying, what is the cap of how many on-site sewage disposal systems can this area accommodate. So yeah, it's more of like a feedback versus, here's a one-size-fits-all, we're going to allow this. I would like more of this kind of mechanism where we can test and identify what is allowable. I don't know if that makes any sense.
I don't see how you're going to be able to test if the law isn't in place to allow the systems to be used.
Yeah, I think that we can do. But as far as identifying how much we can allow, I think that's where the discussion, I think, has to occur. And I think this is something that Brian Beard and I remember we talked about this concept. I believe it's in one of his PowerPoints as well, that what are the solutions? And I think this came up in one of the discussions. But yeah, again, we could talk more about this. I know we have more people, more questions, and more people who want to give testimony. So thank you. Speaker Terlahi, you're recognized.
Thank you very much, Madam Chair. And thank you for those who presented testimony. All the testimony is very helpful today. Mr. Santos, especially yours. I heard it years ago as well. And so I just want to maybe regroup that I do agree. I mean, I think we have consensus on certain things, that even EPA is here telling us type 4 is better than type 2 if we're trying to prevent nitrates from entering the system. So I don't think we're going to find much objection to allowing a type 4, where we are currently allowing a type 2, right? And now examining whether to allow what we have allowed in parental subdivisions for court subdivisions. I think even EPA was saying, okay, but we have to be cautious because we've already exceeded 49% of all unsewered development within our aquifer, or the lens, comes from parental subdivisions. That kind of blew my mind. That's a huge statistic that was not on the table for me before. So if that's 49% of all unsewered comes from parental, what's it going to look like when we what's currently required of court subdivisions to be on sewer, if we're allowing them to go onto septic or the type 4, this 49% is really going to grow. Why do you say no, huh?
I don't think 49%. We're kind of shaking our heads here.
I know, but
that 49% was the number of parental subdivision lots.
Well, that's all right. This is the testimony. Please, Mr. Captain Bearden, if you would like to put that on the record. So the testimony says, however, in recent years, quarter-acre parental lots have accounted for about 49% of all unsewered development within the NGLA.
Yes, for the last 2 fiscal years, FY22 and 23, that is the permitting numbers that we have. It's all, we have permit numbers, everything to base that, to back that up. We provided that data to Senator Dueñas' office as well.
Okay. So there is data to this. This is the thing that's bothering me. It's just the data. We can't be blind to it, right? So when we want to help I want to help the court subdivision people. I definitely want to do that. Of course, we all want to increase housing, but we're not going to say, okay, then never mind the sewer requirement for everybody because we want housing. We just, you know, we're trying to find the zone that we can all feel is a benefit, right? So I just can't, we can't do it blindly, and I just think that's one statistic we've got to be aware of. The other one is that we already have 5,800 homes in the recharge area. 5,800 homes in the recharge area was supposed to be the maximum according to the 1982 study. We are now at 15,500 septic systems within that recharge area. So we far exceeded what they recommended for us to stay within. And so by allowing this exception, not a right, but an exception for court subdivisions, we are going to be further exceeding that. That's all, okay? So, and we have to live with that, and we have to deal with that. So I say, if we are going to allow an exception, first of all, we are probably going to allow type 4, right? We all agree. That's beneficial for everybody. Whether to replace the sewer system with type 4, I don't think that that's really been established or that was supposed to be the intent of the bill. But to replace the type 2 with type 4 or to allow type 4s, yes. To allow court subdivisions to use type 4 instead of sewer, right, on a quarter-acre. Maybe we're going to get consensus on that, right? So I feel like you have been heard. I hear the pleas of Mr. Santos and all those families, but we have to balance that ourselves, of course, which we are trying to hold GWA accountable. But I found it was funny when Mr. Felix, and you mentioned Fred Harecki. He's the PUC. This is the PUC's issue. They are the ones controlling whether they get to spend that money or not spend that money, where they get to spend that money, whether they're going to respond to the consent decree versus put this sewer across the island so we can divide our lots smaller. This is the issue with the Chamorro Land Trust as well. If we can get the sewer into these areas, we can divide those lots smaller. We can put more residential leases in place. You know this, we've talked about this many, many years, so we know the solution, but we're not the only persons who can control it. So what we can control is this. And so I think where we have consensus is good. And I think the only place we really do not have consensus, and that might just come down to interpretation of Section 7. So Captain, the Guam EPA's testimony on Section 7 says, no, this section opens it up for everyone. I know, Gina, you're saying, no, this doesn't apply to anybody else, but if you read it very carefully, I was trying to call the AG up again, because I think that's where it's really going to be. Right now, in fact, there are parts of this bill that are even better, right? More protective, because they require in the groundwater protection zone type 4s, right? But they seem to allow it not just for parental lots or court subdivisions, but for anyone. And that's, I think, where we just have to discern what that language actually says. And if it's for the exception, then I think it will be, for me, acceptable. But for example, if you want to make an additional exception for court subdivisions that they don't even have to be a quarter-acre lot. They can be 7,200 square feet, and you're saying this is not going to happen. Well, then why are we putting it in here? the law is, this bill is going to allow it. And so we don't need it. I say take that out, remove that controversy, and let's just treat them the same and leave it at quarter acres with septic tanks, type 4 especially because they're better, and take care of the court subdivisions. Not allow developers to use this bill to, and I'm not saying developers because they're bad, but because those are huge properties, and we're talking about, just a lot more impact. As you described, Mr. Dueñas, 1,000 lots, let's say, or 1,000, anyways, we take 1,000 lots and do this. It's allow type 4 as opposed to requiring them to hook up to sewer. So,
Senator, for larger lots.
I know, there's another law.
No, those developers are going to have to bring in sewer. The entire
That's
Laddie
right.
Heights.
That's what our current law says. That's what they're supposed to do, right? And that's why I'm just think that's where we have a disagreement. That's where EPA is not, you're saying it doesn't, but EPA is reading it to do that. And we have to resolve that here and now.
Well, they're wrong.
Pardon?
They're wrong.
I don't agree. Because if you look at it, it says, density shall not exceed 2 dwelling units each with type 2 facilities per acre. No one disagrees with that, right? That's current law, in fact. This is in the groundwater protection zone. Or 4 dwelling units each with type 4 facilities per acre, period. This is not for parental subdivision or court subdivision. It's for everybody. That's what they're saying. That's what this bill says. And I think that's where their testimony is coming from, right? That's not current law, and that's not a parental exception. That's an exception for everybody.
But that's a lot parceling. That's a lot parceling restriction. When you go into subdivisions, you have to go to the planning commission to have your subdivision approved.
This is not regarding subdivisions. This is for, it's just saying 4.
It is.
4 per acre is the quarter acre, right?
Senator, you are correct. But what it's saying is, if you have a half acre and you want to cut it to quarter acre, you have to put in type 4 from now on. You can't put in the old type 2. So if type 4 is 50%,
right, but you're not allowed to do that right now, right?
Right now, you have a half acre. You can only have one house, but you have a type 2 system. That currently. And now this law says if you have if you cut it in half, you have to remove your type 2 system of your old and put in 2 type 4s.
Right, that's
what I'm saying. So there's no effect on the nitrate because they're both 50%.
And it's got nothing to do with parental subdivisions, correct? Or court subdivisions.
The next section is
parental. That's the exception, but this one right here has nothing to do with parental subdivisions. Do you see? So that's all I'm saying. I think if you just remove the period and you connect it, or else you're going to do what he's proposing, and that is we are replacing the requirement for sewer with type 4 because we think it's sufficient. Yeah, but I don't think that's what. I don't know. For me, that's where that's why we're having a long discussion. You know, Mr. Santos, for type 2 versus type 4, I think that's easy. We're going to approve type 4. Whether we're going to approve an exception for court subdivision to look the same as parental subdivision, perhaps we can get consensus. I can't speak for everybody, but it seems more reasonable. But whether we're going to allow this exception for all other lots, that's where I think we should just draw the line because of the statistics that we're looking at, right? And that's and so if that's not your intent, it's to allow it for all other lots, then
I think you have to put in a requirement if you're concerned about that any developer that develops over the lot parceling requirement of 5 lots, there's a lot parceling requirement. Once you subdivide into 5 lots, you cannot subdivide any further without going to the planning commission. That's where all these requirements are placed on the applicant.
I know, but you're talking about something totally different. You're talking about subdivisions, and see, I thought this bill was just to extend the exemption that we have given to parental subdivisions to court subdivisions, right, Gina? And now we are going beyond that. That's all I'm saying. That's why this discussion is very confusing, because she's saying this does nothing for all those other lots, but that's maybe not correct according to EPA's
And
reading.
that is why you might want to add that thing, that anything over the lot parceling requirement will fall under the subdivision law.
Gina, can you explain, when you said that developers are using the parental subdivision, can you just explain how they are doing that?
Well, no, I was making a comment on what EPA testified to earlier, that based on what they are looking at, they feel like, they use the word investors are using the parental subdivision law and using that to, so they use the word investor.
Okay, but so you don't see any violations. You're saying it's all parents subdividing. That's what you're saying.
So the only way you can get your map approved is, number one, you go to a registered surveyor who has to adhere to the law and prepare your map in accordance with the law. It goes through land management and it has to clear. Okay, let me just be frank. The rumors that I've heard over the years and the grumbling that I've been hearing over the years is a lot of Chinese contractors are using the parental subdivision law to to buy a half-acre lot, cut it up, and build 2 houses. Technically, they're allowed to do that. So what happens is after you get your map approved, then you deed so you're allowed to cut it up into 5. Most of them only do 2 at a time, but they're allowed to do 5 if the lot size fits 929. You can go up to 5 on a parental subdivision. They have to deed 4 of those lots to their children, and they can keep 1. So the 1 lot that the parent, like if I did it, I can sell my 1 lot, but my children can't sell for a period of 5 years. Mm-hmm. So that's what the law is, and those are the rumors, the grumbling that I've heard from some of the government agencies. Hey, why are they doing that? Why are they doing this? Well, it's the law. They're allowed to do it. Just because their last name is different from Campos and Dueñas and Santos doesn't mean they're not allowed to do it. We're still, I don't know how to say that, but it's not wrong. It is allowed.
Okay, I just want to clarify because I know, all right, that's fine. I just wanted your explanation of what you've seen in your field.
Yes, I've seen that.
So we did talk about the CLTC, and now none of this bill addresses illegal things. We're trying to make legal a certain exception, but we're not dealing with the illegal. I don't think it's legal that sewage is leaking out of the sewer system. That's why we're under consent decree, right? I don't think it's legal that, anyways, those things, I'm just saying, outside the scope of this bill, and if we can stick to it, we can figure it out. But I'm just interested in your research. You said you've been researching this one Fuji system. It's a type 4 system. Is that correct?
Yes.
So you agree that type 4 is better than type 2?
Oh, absolutely.
And you are suggesting that this one brand, Fuji, you've tested this. Weary, what I want to know is if Weary is testing this, Weary, I would hope, is going to propose the parameters that you are suggesting to Guam EPA. For example, these brands are better than others. I don't know. You know, that would be better coming from Weary, or Weary saying this is how it should be installed and this is how it should be operated or whatever, maintained. That type of thing, because I would like your research to pay off, but instead of coming maybe from one company, it should come from Weary. And so I am curious why they're not testifying, and whether I want to put that on the record for me, that Weary agrees with EPA that type 4 is better, that there are certain parameters in operating and installing type 4s that must be followed. And if this is enough, the way we have it in the bill, or there are more. That's all.
Okay.
But thank you for your testimony, and thank you for your testing. Situsmasi to all of you.
Situsmasi, Speaker. Senator Barnett.
Thank you, ma'am. I don't know if anyone can answer, how much does one of these Type 4 systems cost?
Yeah, I can. At least at the time when we first installed it, we first purchased it and shipped it here and installed it. At that time, we were anticipating, actually we were capable of offering it at almost the same price as what the contractors, when you itemize the cost on a construction build, would charge for a septic tank and leaching field. So I don't want to throw out numbers, but at one point in time, if you're going to build a house back in, let's just say it was 2010, and you're going to get a contractor to quote you for a construction, they would itemize it and they would say, this is how much it costs for the home, this is the additional we're going to charge you for your septic tank and leaching field. And that could be in excess of between $10,000 to $15,000. At that time, when we installed it, we were within that budget. We didn't conclude to any particular number as of that time, but we were within the range. So we figured we could offer it at an affordable price. And then when it came to the monthly usage or the monthly expense,
right,
we determined that, well, sewage users pay a service fee monthly for the sewage deposit, I guess, into the sewer line. And they paid approximately, at least at that time, about $25 a month. So that was like $75 a quarter. I don't know if that has gone up or not. I haven't been updating myself on the cost, but I'm sure it has. And so at that time, we thought at around the same amount, maybe $100, we're going to be able to go out there and do a quick inspection and maintenance process on it. So the only difference was at the end of the year, when you pump out the system and you clean it out to get it back into new shape. That was the additional cost of pumping out the system. It was a process that had to be followed, and there was a proper way of doing it. And so the pumping company that would do it would have to come out and do it properly, or of course a certified installer and maintenance guy would do that, and they would be in charge.
Mr. Damiano, would you be a vendor, or are you currently a vendor of these systems?
I don't have any agreements with them at this time. Obviously, when they've come, we've hoped to somehow figure out how we're going to get it here if it worked out. And through the 13 years, we have not contracted to be a vendor. In the United States, they've actually opened up shop on their own. They've opened up their own company and offered the product themselves. In Guam, because of how small we are, obviously, right, the numbers are really, really small. We'll see how that all goes. We haven't had a discussion in that at all. So, but just so you know, initially when we first started to propose it and we were looking at development projects, the ideal situation that we had at the time was let's do a pilot project, not only with a single one, but we're looking at a community of homes, and that's how you test it out. But obviously we have an issue here and we do have a solution. And again, I'm just here to support it.
Senator, I've seen recent bids for these systems, and they're going to range between $15,000 and $20,000 for the system. It's slightly higher than what it costs for a Type 2 system. And also, obviously, the difference would be the kind of soils you have to dig through to place your leaching field. If it's hard rock, it's going to be more. If it's very soft soils, it's going to be less. Same reasoning for the septic tank. So, yeah, it's going to cost between $15,000 and $20,000 for each unit for a regular size Type 4 system for a typical residential unit.
Mr. Dueñas, are there any other hidden fees, maintenance costs, yearly?
Well, there will be, yes, because of the requirements that the system be monitored. Dave says that a quarterly maintenance is required. and a yearly, I guess a yearly cleaning out
Clean
of
up, yep.
the piping to make sure that there are no impediments inside the piping. There is going to be a cost, but I'll tell you what, if I had to do that to be able to build a house in a non-sewered area in northern Guam for my family, I'd do it.
Mr. Dueñas, do you have an estimate? 20,000 high end, and then for all the maintenance and everything you just talked about, do you have like a ballpark figure?
Of?
Cost? In addition to the 20? Like another?
I'd say 15 to 20 for the unit for construction, perhaps a few $100s a year.
Okay, thank
for
you.
Maintenance.
Yeah. Yes, Mr. Felix?
I believe he said what a sewer bill is, which is about $22 a month. So that comes out to about $250 a year. Plus you have to pump it once a year. So probably another couple $100, so $400.
Thank you. I want to thank the panel for the information, a lot of good information from not just this panel, but the previous one as well. And thank you for being here and thank you for your attendance. Thank you, Madam Chair.
Thank you, Senator Barnett. So AV is letting us know that we need to take a break. My apologies, Senator Tadegui. We need to take a quick break for them to reset. So maybe 2 minutes? All right. A recess. We're in recess for 2 minutes.